I am not authorized.
Just a moment.
So I start with an introduction and I try to explain the situation in Italy, also with the help of Dr. Russo, and also if Matteo, the other conference or member of our team would like to intervene, and so we can after we also the other partners. I start only because the Italian experience in this sector is very important. Okay, where are the slides? Okay, so.
Yes, Professor Maugeri, just a disclaimer about the recording of the meeting.
Okay, okay, Amalia, can you?
Yes, just to remind to our partners that according to the grant agreement, we are recording this meeting and we will publish the video recording in the database of the project. That's all.
Okay?
Yes.
Okay, so we can start the subject of this work package is the application of the regulation on the mutual recognition in relation to legal person, or in any case to the assets of a corporation, companies, business. So there are many supranational resolutions which highlights the importance to have models of confiscation which can be applied against legal person in order to face the infiltration of organized crime and in any case the infiltration of illicit proceeds of economic crimes in the legal economy. For example, the European Parliament resolution on organized crime of 2011 stress that not only organized crime has a substantial social cost, it diverts and wastes financial, human and other resources, distorting the free internal market, contaminating business and legitimate economic activities. In some member states, organized crime has infiltrated and became solidly entrenched in political circle, the public sector, and legitimate economic activities. So also in the resolution of 2013, a cost to business estimated at more than 617 billion annually. In also this other resolution in 2016, organized crime groups have shown a tendency and a strong ability to diversify their activities, simultaneously operating on different markets and taking advantage of the different laws in individual member states. Serious problems in the form of penetration into the legal economy. In the report Organized Crime and the Legal Economy, the Italian case of the United Nations Interregional Crime and Justice Research Agency, it is also stresses that reinvesting illicit profit back into the legal economy is a practice which consequently weakens both the economic fabric of society and state institutions. The pollution of the economy through organized crime activity has direct consequences for the political environment. In Italy, the application of confiscation against, in some way, the assets of a legal person is a phenomenon steadily growing. We from the report of our national agency for the management and destination of the properties, it is affirmed that from the analysis of the types of recovered assets across the available database, the real estate is the macro type with the highest number of confiscation and sales. But we can know that the significant weight of companies which confirm that Italy is one of the few European countries seizing confiscating business. So also in the report of about this phenomenon of the Italian House of Representatives in 2016, there is the confirmation of that the number of companies seized and confiscated is growing, and also in the report always of the National Agency for the Management of seized and confiscated a kind of asset recovery agency, Italians. It is also confirmed this phenomenon. And the agency addressed the management of a seized and confiscated business complexes with a specialized and uniform approach to issues arising from the application of a real arbitral measure. So also these data are very interesting. There is this always growing of the number. There is also interesting. It is a circular in 2021 with specific instruction in order to improve a better administration management of these confiscated companies. This is also okay. Also, in a recent research of transcrime, Matteo can confirm, this phenomenon is analyzed. And this report has shown a discrepancy between what criminal invest in what is confiscated by the European authorities. So in this research, the need to improve the confiscation of companies is emphasized. E so the need to appunto improve the application of extended confiscation also against legal person. In any case, it is confirmed by this research that Italy is one of the few European countries seizing confiscating business. It is also because the confiscation of assets in Italy seems to respond better than in other European countries to the development and new trends of criminal investment. In both geographic terms, the expansion of the mafia investment towards north regions, more richer, the richest regions, and also typological ones. So this means the increasing importance of companies and other more mobile assets in the criminal portfolio. There is this trend of in mafia in non-traditional geographic area, in large urban areas of northern and central Italy, and so a wider adoption of confiscation measure in non-traditional area, not in south of Italy, but in northern Italy, in Milan, for example. Also for the growing application of confiscation against foreign criminal groups, Chinese or Eastern Europe groups or not. And so it is important that the Italian experience with the law enforcement agency in this sector. In any case, I would like to stress that in many of the European legislative tools on the harmonization and mutual recognition, it is possible to find a rule about the application of confiscation against the assets of legal person. For example, in the framework decision 212/2005, in Article 3, it is specified that each member state may also consider adopting the necessary measure to enable it to confiscate property transferred to a legal person in respect of which the person concerned has a controlling influence. In the Directive 42/2014, the concept of a property is so wide that it is possible to include also the corporation. In the framework decision of 2006, mutual recognition was affirmed the confiscation order against a legal person shall be excluded even if the excluding state does not recognize the principle of criminal liability of a legal person. And so the regulation consider the legal person as a recipient of the confiscation. In Article 2, we can read the final confiscation is a final penalty or measure imposed in the final deprivation of a property from a natural or legal person. Article 26 establishes that a freezing order or confiscation order can be issued against a legal person and shall be executed even if the excluding state does not recognize the principle of criminal liability of legal person. Article 23 about law governing execution also speak about a freezing order, confiscation order issued against a legal person. And finally, recital 25, where the order is issued against a legal person, the certificate could be transmitted to the member states. Okay, so which is the Italian strategy to tackle the face the infiltration of organized crime in the legal economy? First of all, we have the different form of confiscation, measure designed to control or influence the management of the business, judicial administration, judicial control, some form of a disqualification, administrative measure to limit the firm's dealings with the public administration, and the administrative liability ex crime of enterprise, a kind of tertium genus between administrative and criminal liability. So the different form of confiscation against natural person can't be applied directly to legal person, but in the Italian legal system, each form of confiscation against natural person can have as object the shares in legal entity held by the convicted person, if they are the direct or integrated proceeds or the practice or the instrumentalities of crime, or the convicted or the suspected person in the case of non-conviction-based confiscation, confiscation preventive measure, and or the status of an enterprise in the direct availability of the confiscation recipient, if such assets are considered to be proceeds, products, or instrumentalities of an offense. Also, in the case of the confiscation of the proceeds in equivalent form, the confiscation of the value. We have analyzed in the other workshop in the previous work package a different model of confiscation. I would like only to remember that in Italy we have the traditional form of confiscation, Article 240, and many mandatory form in criminal code, in special legislation, with the confiscation of the proceeds when there is the proof of the illegal origin of the instruments and the products of the crime. There are always more special forms that are mandatory also for the proceeds, mandatory form of confiscation. It is interesting in this sector, in relation to the fight against the infiltration of organized crime in the legal economy, the confiscation against mafia association, mafiosa association, of Article 416 bis, paragraph 7. Because it's confiscation of the proceeds, fruits and investment and the instrument of the crime. And in some cases, the company has been considered, was considered the instrument of the crime. And in Italy, we have also extended form of confiscation, extended confiscation after conviction, Article 214 bis, and the preventive measure, non-conviction versus confiscation. The legal person can be considered in some cases beneficiaries. So this means a legal person who don't participate in the commitment of the fact, but receive directly, without intermediaries, the proceeds of the crime, or mala fides third parties. When knew or have to know or had the reason or have had the reason to know the origin of the instrument, products or proceeds, or the purpose of the transfer was to avoid confiscation. In any case, in our system, the beneficiaries cannot be considered extraneous to the crime, because it is not possible to apply the confiscation against the extraneous of the crime, but when somebody, also a legal person, is a beneficiary, is not considered extraneous. This has been affirmed by the Supreme Court and by the Constitutional Court. Okay. Okay, I don't repeat. I suppose that you remember about the different form of confiscation. Not only it is possible to apply this form, in particular the form of extended confiscation against the asset of a legal person when the owner is somebody who is convicted or suspected of some criminal activity. But there is an interesting approach of the Italian Supreme Court in order to seize and confiscate the whole enterprise, the company, the business. In some case, the court uses the category of mafia enterprise to justify the confiscation of the whole business, an entire business, or compendiums of all company shares, without considering whether the capital invested in the activity of the company has licit or illicit origin, and whether the economic activity in which it was invested was licit or illicit. So what I would like to say is that in some cases, the Supreme Court, when there is the confusion between licit and illicit process, when the illicit process are invested or used also in original licit company, or where the original capital is illegal, also it is used in a legal way. In both these cases, the approach of this report is to consider the whole business mafioso, dangerous, so to apply the confiscation. The initial capital is of a lawful origin, has been invested in a legal activity. The lawful initial capital has been invested in a lawful activity. The whole economic contaminated enterprise, regardless of the origin of list assets of the assets, the mixture does not allow for a distinction between lawful and unlawful. Notwithstanding this form of confiscation should affect only the illicit proceeds or the reinvestment of criminal assets, the court confiscates on the basis of this case law the whole economic contaminated enterprise, regardless of the origin of the assets. For example, in this judgment, the court affirmed that it was not possible to operate the claimed distinction, given the unique character of the company, which is the combined and synergistic result of a capital, capital goods, labor force, and other components legally incorporated and united in the pursuit of the aim represented by the exercise of the company as defined in civil law. The whole agreement constitutes an autonomous economic and social reality in which the contribution of list components cannot be discerned by that attributed to illicit resources, especially when the consolidation, exponential expansion of the subject companies have been supported from the start by the mafia organization in a perverse circuit of common interest. The initial level of character of the share paid by the various partners becomes irrelevant where the life of the company has been conducted by lawful means. Also, the extensibility of a confiscation to the entire corporate group from the liquidation of any anatomist approach also derive the extensibility of confiscation to the entire corporate group. Because in any case, the group has benefited from the considered contiguity with mafia. Another approach in order to apply the confiscation against corporation is also to forfeit an entire enterprise considering the owner mafioso and applying the assumption that if the owner is mafioso, the enterprise must be unlawful, must be mafiosa, dangerous. So there is this inference from the dangerousness of the owner to the dangerousness of the enterprise. For example, it is a judgment of the Court of Appeal of Caltanissetta. Once the social dangerousness of a proposed person has been ascertained due to his relationship of contiguity with the world of a mafia organized crime, it is not necessary to proceed to a further ascertainment concerning the illicit origin of the individual asset. So these two approaches are very efficient, but also problematic. It sometimes also this approach, mafioso, illicit, when there is confusion among licit and illicit proceedings, is it possible to consider the whole enterprise, the whole business illegal, has been applied not only against the infiltration of the mafia in the economy, but also in relation to persons suspected of other crimes, including tax evasion. Now in Italy, with the after in particular the reform of 2008, it's possible in the practice to apply also non-conviction-based confiscation against people suspected of each crimes. And so it is possible also to apply this inference, no? When there is a confusion, it's not possible to distinguish between lawful and unlawful, and it's possible to confiscate the whole enterprise. This approach is also more unjustified when we don't speak of mafia, but of other crimes. And the problem is that a similar assumption is used as a sort of experience rule applicable without checking whether in the concrete case this rule is valid and is realized in practice, in particular when there is a rule that if the owner is dangerous, also the enterprise is dangerous. In the opinion of before of the authors, but also in the opinion of a different of the Supreme Court in a different approach, in a more grantistic approach, it is important to distinguish. When there is an original mafia business, an enterprise owned by the mafioso. An original mafia business means enterprise characterized by a strong individualization around the dominant figure of the founder, who runs it directly with the mafia method, or an enterprise owned by the mafioso, who does not manage directly, but runs the business through a dummy, figurehead. In this case, there are less problems because the companies are created with the capital of illicit origin and managed with the mafia method. So in this case, it is not problematic to confiscate the whole business. But another case is more problematic, the case of enterprise with mafia participation. This means that the owner is not a dummy, a figurehead, but is a real owner, represents his interest. In this case, it is important and in a different approach, in a more grantistic approach, the Supreme Court has also affirmed that it is important to verify if the company is managed with the mafia methods and when this mafia contamination started. The company original legal has become a tool in the hands of the mafia through extortion, expropriation, or money laundering, or if the company has only had some relation with organized crime without alteration of the business secret. For example, also depositing of money to launder without alteration of the business secret. Because in this case, in this second case, it is not justified the confiscation of the whole business, of the whole enterprise, the company. So in the first case is justified when the company is managed, it becomes a tool in the criminal organization, but when there is only this participation without the compromising the whole economic activity, there is the need to limit the seizure and confiscation only within the limits of the lawful procedure and reimbursement. Otherwise, a too wide interpretation of the mafia enterprise concept transforms the confiscation of proceeds and the reimbursement in a form of a general confiscation, in a form of punishment. It is also another approach in order to confiscate the whole enterprise is applied, consider the enterprise an instrument of a mafia association. And so there are some, in some cases, the Supreme Court, so with this approach, confiscated the whole business when the owner are considered participant in mafia association. The necessity to limit, to apply, the confiscation, the needs to apply in a correct way the confiscation only in the limits of the illegal process when there is only this participation, when the whole business is not mafioso or illegal. Derives also from recital 11 of the Directive 42. Where in this recital is affirmed that when the process being mingled with the property acquired from legitimate sources, is possible to confiscate only up to the assessed value of the intermingled proceeds. And also from the principle of proportionality that is affirmed, recognized in the recital 17 and 18 of the directive, and in the new proposal for the new directive is affirmed also in the Article 23, paragraph 5. And also the approach of the Constitutional Court, in Italian Constitutional Court, is to apply the statute of safeguards in relation to confiscation, extended confiscation, and non-conviction-based confiscation, preventive measure. That means not only to apply the principle of legality, the principle of due process, the right of defense, but also the principle of proportionality. Notwithstanding, the Constitutional Court doesn't recognize punitive aim or nature to extended or preventive confiscation. But in any case, the Constitutional Court affirm the importance of the principle of proportionality. And in some other judgment, the Supreme Court has an approach more careful. In many judgments impose the respect of the guarantee of the property right and of proportionality. So it is important to assure the confiscation only up to the assessed value of the illicit proceeds. And in any case, as affirmed the Supreme Court, that it is not sufficient for the purpose of the adoption of mutual confiscation to verify only the existence of evidence that the subject belongs to a mafia association, the dangerousness of the owner, in order to believe that his assets are of illicit origin. But it's also necessary to have evidence inherent to the assets which leads on to believe that the same are the fruit of illicit activities or the reuse. So a subjective and objective assessment. It is interesting that this case, Sina case, and in the affirmation of this judgment of the Supreme Court are also repeated in more recent judgment. It is very important because in this judgment the court states correctly that the illicit origin of the company assets or the corporate share cannot be inferred from the fact that the owner is suspected, is a membership of a mafia organization, or does justify the application of a patrimonial measure, but only of a personal preventive measure. In this case, the measure was applied only because the owner showed his availability it will to be at the disposal of the mafia organization, but he wasn't a a member of a mafia organization. And the court say that is not enough. Okay, and in particular the court demands the proof, at least at the level of circumstantial evidence, that the original purchase was made possible by the buyer's unlawful activity carried out in any way, extortion, fraud, trafficking, without demanding a proof of a direct link in the form of a causal link, that the growth and the accumulation of wealth by the company was actually facilitated by illegal activity of the holder belonging to the mafia, and requires the Supreme Court that the former at least used his mafia quality to create favorable conditions, putting in place the activities appropriate to impose illicitly the enterprise in the market. Unfair competition, acquisition of capital equipment with affordable price, mafia control of labor, and so on. Because only in this case it can be said that the capital increase is the result of illegal activities. It is approach as has been also recognized in other cases. So it is also interesting, it is as judgment, confusion is not regulated by the Italian law in this sector, but notwithstanding the confusion, the principle of strict legality and of a constitutional compatibility of the system impose that the object of the seizure can only concern only a set of disproportionate value of illegal owning. It is not a form of general confiscation of assets. General confiscation is known in other systems of law, for example, in France or in Switzerland, against a criminal organization. In a project, an Italian project in 2000, there was Article 117 that provides for the dissolution of companies or associations that have been used exclusively or predominantly to carry out criminal activities, and that this sanction, this dissolution, is included in legislative decree 231 of 2001, the decree about administrative liability for crimes over the legal person, but only when the enterprise is an instrument or is exclusively destined to criminal activity, and in some very serious case. So the problem is the management of the seized and confiscated business. In Italy, we have a special legislation. We will study this legislation in the next work package. But in the practice, also is recognized that in the most cases, the companies, the destination is for the companies is liquidation. Notwithstanding the complex legislation about the management of the seized company, a confiscated company, in the end, the solution is the liquidation. In some cases, it is not possible for a company who lived in a legal way to survive in legal way, in the respect of the law. But in other cases, it is also a consequence of a bad or also of the difficulties to manage a company an enterprise by the judicial administrators. So, in any case, according to the most accredited data, only 3 out of 10 companies reach final confiscation invoice. This, in Italy, there is a different legislation in order to avoid the confiscation and to try to solve the problem in a different way, try to the legalization, no, of the illegal company. So I would say something about this other instrument, judicial administration. The judicial administration is a preventive measure in the anti-mafia code. This provision regards assets used in the running of economic activity, which, based on sufficient grounds, are considered objectively useful for the activity of a person, so who are being considered for preventive measure or are defended in ongoing criminal proceeding for crimes linked to organized crime. So we are speaking of a business which can be absolutely legal, but this business facilitates the activities of a suspects, subject to preventive measure or defendant in trial, in criminal trial, when there are sufficient reason to believe that the free exercise of economic activities facilitate the activity of a person in respect. Okay, so in the beginning of the application of the introduction of this measure, the prosecutor, the judge, didn't want to apply because there were some doubts about too wide anticipation of the application of preventive measure. In relation to when the owner is not suspected, but the business facilitates the activities of a suspect. So, but in the last years, the prosecutor and judge have recognized the positive aspect of this instrument. That in the possibility to, because this instrument, okay, which is the content of this instrument. The managers are removed. The court nominates a delegated judge and the judicial administrator who has to manage the business. The judicial administrator has to present a statement about the economic activity and has to manage the entire business, not only the proceeds of the instrument of a crime. So, in this case, there is not a fixed interposition between the third party and the proposal. The business is of the owner who is not suspected. Okay. The law, what demand? Effective and conscious facilitation of this person suspected, a nexus of instrumentality between a specific business and illegal interest, and awareness, but also works for the enterprise, of the quality of the advantage person and of his aims. But what is more important is that aim of this instrument, this replacement of the management for a specific period of time, is only to turn away the organized crime, to cut the relationship between the economic activity, the business, and the organized crime, to reclaim the business. In particular, and this is also possible, it is possible to apply this instrument also in relation to victims of organized crime. There are some doubt over the authors about the opportunity to apply this instrument against a victim, but the approach is not to punish, but to give an instrument to cut the relationship, to cut the infiltration of the organized crime and the decontamination of economic activities affected by mafia infiltration, but basically healthy. The more frequent use of the suspension of the judicial administration can be very interesting for the companies, in particular for more complex and big companies that have the interest to self-regulate, removing the gray area which made them vulnerable and contiguous with respect to criminal plots. So it's a kind of a therapy against the infiltration without a punitive aim. It is interesting, one of the first cases where this measure was applied, TNT, a Dutch company working in Lombardia, judicial administration was applied due to the 'ndrangheta infiltration. The TNT used in Italy little enterprises connected with 'ndrangheta. After only 5 months of this measure, the court overruled the measure because the multinational company has realized a serious compliance in order both to cut the connection with organized crime, which had motivated the initial judicial intervention, and to adopt adequate preventive tools for averting the risk of future relapses. In the opinion of the court, the control of companies or cooperatives that provide service on behalf of TNT translates into the ability to infiltrate into a large volume of a business. The 'ndrangheta has the interest to infiltrate TNT, but on the contrary, for the mother company TNT, it is not found that there was a clear self-interest in entertaining at the peripheral level privileged relation with the companies controlled by the mafia. So it was a big company, and the measure was very efficient in this case. In this case, it is also important that the company adopts a new compliance program in order to prevent for the future the risk of crimes. Also, this other judgment of the Tribunal of Milan, this measure taken away, the aim is the sterilization of the company, is economic activity from contagion. Without the instrument, the suspension and then dismissal, not only of managers directly involved in relation with the mafia subjects, but also of those reprehensible for failure to control up to the replacement of top management. The adoption of a new organizational model, complex program, under Legislative Decree 231 of 2002, the legislation about the administrative liability for crimes of the legal person, to prevent the mafia intrusion. In any case, this measure has to work as a bisturi, useful to operate selectively in the considered economic activities, because this instrument can be dangerous if we apply. There are some doubts against only victim without this correct approach. It should concern only to certain economic activities that facilitate criminal interest. Another important case is the Uber case. is the case of the exploitation of work. In this case, it was not a case of infiltration of the mafia, but of in any case of unlawful activity. And also in this case, the court affirmed that the aim is not punish, but to counter the lawful condemnation of wealthy enterprises, subjecting them to judicial control with the aim of removing them from criminal infiltration. Okay. In some cases, the court has not, for a limited period, applied the replacement of the management, but only a kind of monitoring with a tutor. So I realized the mission is a different way. Tutoring, no? The content disorder. Okay. In any case, it is very important, this instrument, because it's a very good instrument to safeguard business continuity, avoiding economic losses, guaranteeing the effectiveness of the management intervention, protecting the employment needs, to avoid the loss of job, and preventing to public support for the future the risk of crime, of a mafia infiltration. Recovery to free competition following an amendatory pathway. Advantages: it can allow us to affect the whole business even if only some partners are involved in criminal activities. Judicial administration is not definitive. It will be easier to maintain the continuity and productivity of the enterprise. In the practice, the temporary suspension was in the past was a theoretical hypothesis, but the situation has changed in the last few years. Because appunto it is considered a very good instrument in the case where mafia influence do not justify seizure and confiscation. That can be cured through the removal of directors and or polluted executives, switching suppliers and subcontractors. Okay. The risk is that the victim, to apply this measure also to victim, but in any case, if it is applied in a correct way, it can be useful. And there are other disadvantages. It is not possible to appellate this order. And in the opinion of some authors, it expresses the culture of suspicion, but this is also when it is applied against a company that is only victim. But in any case, we have another instrument that has been introduced in 2017, the judicial control of enterprise. That is also less invasive, because in this case there is also the tutoring, a kind of monitoring. When the facilitation of when the legal business facilitate the economic activity of a suspected or defendant, but this facilitation is occasional, the court can order only the judicial control of economic activities of where there are facts from which it could be inferred that the real danger of mafia infiltration suitable to influence their activities. So there is only this occasional facilitation, and there is the this suspect of danger, of the real danger of a mafia infiltration. The judicial control in this case, there is not the replacement. There is a judicial commissioner with specific control task on the activity management. And so it is also this instrument, the temporary suspension, judicial control, can be an interesting alternative. In particular, against companies infiltrated by the organized crime, or in any case by economic crime, without necessarily resulting on their definitive confiscation. The management of confiscated assets, in particular the confiscated company, should improve rapidly. In any case, a good management is the necessary requisite for effective. No, sorry, but another, and I conclude, sorry, maybe too long, another instrument in the Italian system of law is also the disqualification interdittiva. Is a preventive measure, also included in the anti-mafia code, applied by administrative authorities. What means is prohibition to conclude contracts, obtain authorization and concession, and in general to have legal relation with public authorities. When there is some suspect or any attempts of mafia infiltration. When there is this certificate of the existence of an attempts of a mafia infiltration aimed at influencing the choice and addresses of the concerned company of affairs. Okay. And the mafia infiltration can be inferred by a series of judicial proceedings for serious offense, including obstructing of public contracts, and as well as the investigation ordered by the defense. So the problem is that this administrative measure, this disqualification is only an administrative measure without jurisdiction, is applied by the prefect, is an administrative authority. Is imposed, this measure is very invasive because the relationship with the public administration are closed, are cut, and is imposed with fewer safeguards. Without the jurisdiction, without the contradictory. Only in the last reform, there is the rule that before to apply the measure, the administrative authority has to invite the recipient for a hearing. But in any case, has a significant impact on the firm, blocking all economic relations with the public administration on the basis of the mere suspicion of a mafia infiltration. It can be very useful to prevent the infiltration of organized crime, but in a very problematic way in terms of respect of the safeguard of the rule of law. So there are some in the practice that can be more severe for the firm in comparison with the judicial administration and judicial control, because when the judicial administration or the judicial control are applied, is it possible to carry on the economic activity. In this case, with the disqualification, the economic activity, if it is an activity, it is the case with public administration, the activity is interrupted, is not possible to carry on. So the economic consequence can be very serious. There are many doubts in Italy about the application of this measure, but in any case, in the practice, they are widely applied. The company can ask for a judicial control in order to interrupt the effects of the disqualification and to demonstrate that the economic activity is legal. in the practice, we have many cases of companies which require the application of a judicial control against the disqualification. In any case, in order to conclude, this judicial administration, judicial control can be a very interesting measure against the infiltration of organized crime or economic crime in illicit economy without the problems and the consequences of confiscation. But when the company, the enterprise is fundamentally healthy, only with some infiltration. Okay, so I conclude, and Dr. Russo can I give you the floor.
Thank you. Good morning. I am Diana Russo. I am a prosecutor. I've been working at international cooperation of Ministry of Justice since 1 month. I just want to add something about the nature of the responsibility of legal persons in our set of rules. The Italian legal system does not provide for the criminal liability of legal persons. Article 27 of our Constitution provides the principle of personality of criminal liability. Legislative Decree number 231/2001, which regulates the administrative responsibility of legal persons, expressly qualifies the liability of legal persons as administrative liability deriving from a crime. However, the ascertainment of liability of legal persons is carried out by a judge within the context of criminal proceedings and with the guarantees typical of criminal proceedings. So, according to Legislative Decree number 231, confiscation is an administrative sanction deriving from a crime. In case of conviction, the confiscation of the price or profit of the crime is always ordered against the entity. When direct confiscation is not possible, the confiscation may concern sums of money or goods or other benefits of equivalent value to the price or profits of the crime. I just want to add another thing about alternatives to freezing and confiscations. As we have just heard, these alternative measures are provided by so-called anti-mafia code. These non-ablative prevention measures are residual compared to the ablative capital prevention measures. They do not involve the dispossession of assets. They pursue the aim of reinserting assets into the circuit of legality, and they can affect third person because they apply the companies instrumental to criminal activities. They apply to companies that permanently or occasionally facilitate criminal activities. So, in my opinion, this kind of measures better comply with the rule of law principle with particular regard to the proportionality related issues, because, again, these measures, the aim of these measures is to reinserting assets into the circuit of legality, and they can affect also third parties. Just this few considerations. I thank you, and I apologize because I'm going to disconnect for a while, but I will join the meeting again later. Thank you very much.
Thank you so much. So, it is important also this instrument, the administrative liability and the confiscation, which is included in this law directly against a legal person. In Italy, we speak about administrative liability, even if in the practice, also in the application with the Supreme Court, the principle, the trial is a criminal trial, the principle of the Constitution in relation to criminal matter are applied. So in the practice is considered a kind of criminal liability. Also in the debate in the last years in conclusion. And it is also, in this case, we don't have extensive confiscation, but only the confiscation of the proceeds of the instruments of the crime and the confiscation of the value of the person. So, but in the practice, the judge, the prosecutor also of the Northern Italy have applied in the last year more the judicial administration or the judicial control against legal persons which are healthy and are not applying the administrative liability for crimes. I suppose because these instruments are applied in a easier way with less and also with less safeguards. But in a recent speech with prosecutor of Milan, he told that in any case the corporation avoid what is considered a kind of a criminal trial. And they prefer, he said, I don't know if it is true, they prefer judicial administration in comparison with the application of the administrative liability for crimes. So if there are some question about what is and I don't know if Matteo or Pietro would like to add something. Matteo, I don't know, maybe.
Can you hear me? Yes, thank you. Thank you. Thank you, Professor Margelli. No, I don't have many things to add. You really had a very comprehensive overview of the system. I just wanted to stress that, in my opinion, all these problems, all these issues are also and often a problem also of tracing of assets at a European level, as we highlight also in our report in 2015. There's a huge problem in confiscation of immovable goods, since they are very of assets in general and legal persons, because we don't know what belongs to who in Europe, and this is a huge challenge for the European current framework, the beneficial ownership of European companies. And we can see that in many fields, in many different subfields in the criminal enforcement, I would say. And another point that I wanted to stress is that, as we have seen, we confiscate much movable goods such as cash and vehicles, and we don't succeed in confiscating immovable goods, meaning also legal persons, also for this reason, meaning it is maybe a paradox, but it seems more difficult to understand the beneficial ownership and the property of immovable goods compared to movable goods in some situations, or in this framework. But this is all. Thank you. Probably, I believe the professor has some connection issues.
Yes.
Yes.
Yeah.
Okay. Maybe now.
Yes, the connection is not working.
The next partner should be France, but France informed us that they cannot be present. So maybe the next partner who can speak is Spain, but we can wait for
Sorry, I had a problem with the computer, so I changed the computer. Okay. Okay, if there are not issues, are there some issue? No. So we can carry on with the next in the program.
Spain, because
Spain.
France cannot be present. Yes.
Okay.
Yes. Good morning. Can you hear me? Yes. Okay. We have sent the answers to the questionnaire. Have you received it, Amalia? Yeah.
Yes.
And I have sent also this morning before we start this webinar PowerPoint presentation. Have you it?
Yes, I have it.
Can you put it on the screen, please?
Of course.
Thank you.
Just a moment.
Well, while you are putting the PowerPoint presentation on the screen, I will also underline that, well, the answer to this question, we have been involved in answering it, the whole unit, the International Cooperation Unit, but I would like also to underline that José Miguel Company, my colleague José Miguel Company, was also really pretty much involved in the drafting of these answers. First thing I have to say that this is a real tricky issue. It's not easy to deal with, and mainly because there is a lack of experience. It's really a novelty that we have in our legal system since 2010, but pretty much underused by the practitioners. At that time, in 2010, it was a novelty that everyone was waiting for, overcoming the traditional action of criminal law, societas delinquere non potest, the rule that prevented a legal entity from being held criminally liable. Sorry. We move from that action to another one, the societas puniri potest, that can be considered one of the milestones of modern criminal law, mainly following a Council of Europe recommendation in 1988. I'm facing the need to tackle the growth of and the increase of corporate criminality in the context of economic crime. Spain decided to take into our legal system this new concept, this new action. As I told you before, in 2010, by the end of 2010, but latterly this model, this approach was enhanced and clarified by law, by another law, organic law, in 2015, transposing the 2014 directive into our national legal system. And from the General Prosecutor's Office, we have two very interesting documents. One circular of 2011 and an instruction from 2016 interpreting the application of these new legal reforms and of the criminal code. The most important change is, from my opinion, is a change of nomenclature, of terminology. It lies in the fact that from December 2010, the fine and the eventual accessory consequences are called penalties. And then, as I told you before, we move from societas delinquere non potest to societas puniri potest. And the main article of this reform is Article 31 bis of the Spanish Criminal Code. And this article, this provision establishes a twofold normative mechanism for the attribution of liability based on the so-called vicarious liability regime, combined also with a numerous clausus system of listed crimes, listed offenses in the Spanish Criminal Code. In relation to the question, how was the directive 2014 transposed, 2014-42 transposed in our legal system? Well, criminal liability introduced in the Spanish Criminal Code turns around a principle according to which any criminally punishable behavior is still committed by natural persons. This is exactly the same as the previous system. Natural persons who act on behalf of, in the name of, in the capacity for the direct or indirect benefit or within the scope of the activities of a legal person. And this misconduct will be directly referable to a legal person. And this is the so-called criminal responsibility by transfer or indirect or vicarious or by representation model based in the principle of imputability of a crime to a legal person. But it's something different from the concept of objective liability, which is unconstitutional under the constitutional regime that we have in Spain. Therefore, under the Spanish legal system, the legal person itself does not commit the crime, but becomes criminally liable for the crimes committed by others, namely natural persons. So this system is not based on the autonomous liability of the companies. That is the first thing that should be very clear. And I think is in line with the Italian system that Mrs. Maureghi just told us. This approach is also in line with the EU legal framework. Yes? Sorry? Okay. This approach is also in line with the EU legal framework. You see Article 5 of Directive 2012 on preventing and combating trafficking in human beings, or Article 10 of the Directive 2013 on attacks against information systems, or Article 6 of Directive 2014 on protection of the euro and other currencies against counterfeiting by criminal law. The Spanish Criminal Code, after the 2015 legal reform, maintains the essential basis of attribution of criminal liability to legal persons on the basis of this so-called vicarious or vicarial, I don't know exactly how to name it, system. According to the Spanish Criminal Code, two conditions have to be fulfilled in order to for criminal liability of a legal person to be established. First, a crime has to be committed by a natural person, as I told you before, and there is an exhaustive list of crimes, and we will see it later on, imputable to a legal person. Secondly, there must be a causal link between the interest of the or the activity of a legal person and the illegal contact of a natural person whose is imputable to that legal person. However, in our Spanish criminal code, law 2015 made a step forward towards the recognition of certain autonomous liability of the legal person by means of the regulation of the what is the so-called organizational programs, the compliance programs, to which it attributes an exonerating value. The Spanish criminal code attributes an exonerating value and not a mere mitigating consequences, but under certain conditions. That is the main difference between the initial reform that we have in 2010 and the later reform in 2015 in relation to the organizational programs. In general terms, the Spanish criminal codes introduce 3 categories of natural persons whose illegal conduct is imputable to a legal person. First, a statutory body or corporate body, or a member of a corporate body of the legal person, person vested with supervisory powers in the legal person, within the legal person, and other person legally authorized to represent or decided on behalf of the legal person. These are the 3 categories. According to the Spanish criminal code, regional, state, and local administration entities are certain legal persons established by law are exempt from criminal liability. However, it should be also stressed that the fact that these entities may hold shares in other legal persons, private companies, does not shield such legal persons from being equally criminally liable under the Spanish legal system. Actually, the law 2015 law extends the liability regime to public corporations in new Article 31 quinquis of the Spanish criminal code. Well, moving to the catalog of crimes which are imputable to legal persons, we have a very long list. You have it in the PowerPoint presentation in slides 3, 4, and 5. Namely, confiscation of assets in Spain is possible when one of the following crimes have been committed. First, and the list is very large, as I told you, is money laundering, of course. Second one is illicit trade of human organs, and I also include in the slide and in the report the concrete article where this liability is criminal liability for legal person is provided, because this is essential under the Spanish system. Also torture and other crimes against moral integrity, trafficking in human beings, prostitution, like sexual exploitation, sexual harassment, child abuse of children and child pornography, swindling and frauds, bankruptcy, and also damages, intellectual property related crimes against the foreign citizens, urban planning related offenses, environmental offenses, crimes against animals. It's a very long list. I would like also to focus on computer-related crimes, where you have different types of offenses: computer hacking, online fraud, discovery and disclosure of secrets, and computer trespassing of personal data, and also IPTV crimes, Article 288, and corruption related offenses like bribery, trafficking with influence, embezzlement of public funds, illegal financing of political parties. These lists have been built up from 2010, also was completed in 2015, and in recent reforms in 2023, the Spanish legislators had also the opportunity to include more offenses in this large list of offenses. But it's very important to know that only there is another catalog of reckless crimes, and the only 4 reckless or imprudent behaviors committed by national persons under the circumstances of Article 31 bis of the Spanish Criminal Code, able of producing a criminal liability for the legal person, are those related to bankruptcy of punishable insolvencies, crimes against national resources and/or environmental offenses, money laundering, and financing of terrorism. There is a new definition, a complete new definition of natural persons in Article 31 bis. That is the main provision in the Spanish Criminal Code in relation to this issue. And the new definition significantly enlarged the ring of subjects under the vicarious imputation criteria, which make this possible to include those who, without being properly speaking managers or legal representatives of the company, are part of members of its corporate bodies with decision-making capacity, as well as middle management individuals with power of attorney and other persons to whom certain functions have been delegated by the legal person or the entity, including the risk control functions held by the compliance officer or the so-called compliance officer. And there is another peculiarity of the Spanish criminal system, is the dual sanctioning route or circuit. We have, in parallel with Article 31 bis, we have another article, Article 129 of the Spanish Criminal Code. And this article provides for a complementary punishment regime in relation to concrete offenses committed by entities without, the so-called entities without legal personality. And namely, these offenses are related to genetic manipulation, alteration of prices in public procurement tenders or public actions, offenses against the workers' rights, counterfeiting of money, the membership of criminal organization and groups. In any case, the Spanish courts will always need to determine and to, in a motivated decision, that when it comes to confiscation, given assets should be the outcome of the above mentioned criminal categories. Being said that, Article 129 of the Spanish Criminal Code set up the following. In case of offenses committed within, in collaboration with, or through or means of companies, organizations, group, or any other kind of entities of group or persons without legal personality, as I told you before, which are not included in Article 31 bis of the Spanish Criminal Code, the court may issue a decision applying to them several ancillary consequences, what we call accessory consequences. That the legal nature of these ancillary consequences, in principle, they are not penalties. There's a tertium genium category, and these auxiliary consequences are to be imposed on the perpetrator, the natural person, with the content provided in Article 33, which is regulating penalties applicable to legal persons. Then ancillary consequences are measures like suspension of the activities of the entity without personality, closure of the premises and commercial establishments of these entities, prohibition to carry out the activities through which it has committed the offense, banning participating in public procurement tenders, as I told you before, and disqualification from the ability to receive grants, subsidies, other benefits, public benefits, including EU structural funds, and a judicial intervention or administration to safeguard the rights of workers or creditors for the time deemed necessary. In relation to these measures, final banning or prohibition to carry out any activity can be also decided. The ancillary consequences mentioned before may also be applied to, as I told you before, to firms, organizations, groups, or entities or association when it is specifically foreseen in the Spanish Criminal Code, or in relation to offenses for which criminal accountability or legal pension is provided. And in relation to the temporary close of premises, that is a precautionary measure that could be adopted not by the court, but at the beginning of the criminal investigation by the investigating judge, and suspension of the corporate activities of judicial management with a judicial administration or intervention. These measures might be ordered by the investigating judge, but also with a legal remedy system in order to judicially supervise or monitor the proportionality of this measure. Because this combined dual sanctioning circuit was set in place in the Spanish system in order, following the recommendation of an effective, proportionate, and dissuasive sanction regime, as recommended by, for example, the G20 high-level principles on the liability of legal persons for corruption, and but it should be also be assessed in a proper way, taking into account the proportionality clause and proportionality principle. In relation to the models of confiscation applicable against natural person in Spain, and this is slide number 8. In Spain, each model of confiscation, like in the Italian system, is only applicable to national persons, but they could indirectly affect the assets belonging to legal entities. In this situation, the main problem is when it's related to beneficial owners, as previously mentioned by Anastasia Mateo. These beneficial owners or the shareholder of companies, when they are not clearly identified, well, we have to use the investigation, the financial investigations, in order to clarify this relevant aspect. Otherwise, we are not going to be efficient at all. The Spanish Criminal Procedure Act is lack of adequate rules, and this lack of legal basis is not the most steady scenario we need in relation to financial investigation. It is unclear whether the judge can order law enforcement authorities to conduct an investigation on its own. And additionally, it is also unclear whether the prosecutor must be consulted before conducting this type of investigation when the investigating judge acts ex officio. Then the case scenario should be improved. In relation with the models of confiscation that can be applied directly against legal persons, well, according to the legal reform of 2015, the extended confiscation was also established under a numerous clauses system in Article 127 bis. However, confiscation models are only applicable to natural persons, as I told you before. Which are the legal nature of the confiscation against legal persons? This is also an interesting question, and I am moving forward to slide number 10. Well, the legal nature of confiscation in Spain is mainly an ancillary consequence. It's not, properly speaking, a penalty, and is the same regime for the legal and national persons, as we previously stated on several occasions in our national reports. There is a recent Supreme Court judgment passed on the 25th of January of this year, and in this case law judgment, you can find a very clear definition of confiscation, and the court held that this is a sort of third class in criminal sanction. Thus, and following the Germanic law models of regulation of criminal sanctions, the Spanish criminal code established, as I told you before, a sort of third kind of penalties under the heading of legal consequences or ancillary consequences. According to this, we have noted that another judgment from the Supreme Court pointed out that although confiscation is not included in Article 33 of the Spanish Criminal Code, that is the catalog we have for penalties, it really constitutes as sanctions based on the principle of culpability or proportionality, and also the legality principle is impacting the application of confiscation at the end by the Spanish courts. What is the standard of proof that we have in relation to procedural rules? As we told and we explained in the first national report, the standard of proof is ruled by the needed standard of the proof for confiscation is not the probable clause, but the indirect or circumstantial evidence. Indirect and circumstantial evidence and for the demonstration of the unlawful origin of the criminal assets is enough. And there are a set of presumptions that are legally established in our criminal code that should be taken into account by the courts. In relation to safeguards, proportionality clause is established in Article 128 of the Spanish Criminal Code, and is also applicable to legal persons' criminal liability. In relation to what Professor Mauregui refers as a judicial administration of management of companies, there is a provision, Article 33, and in the last paragraph of this article, the Spanish legislator provides the intervention may affect the whole organization or be limited to some of the premises of the organization, or sections, or business units, then the legislation is also provides for the possibility to have a tailor-made, a proportionate approach when it comes to the judicial administration. The court shall determine exactly the content of the intervention and shall also determine who shall take charge of the intervention and within which regulatory monitoring reports must be submitted to the judicial body. And that was also ratified by a judgment of the Supreme Court in 2016, setting up that the fact that the lawful structure and tasks of the legal person were used by the natural person to commit the offense does not necessarily means that the whole organization must or should be under the judicial intervention. In relation to legal remedies regime, the confiscation order adopted in the conviction sentence may be challenged on the general basis, legal basis regime provided in the Spanish Criminal Procedure Code. Likewise, precautionary measures adopted by the investigating judge during the investigation phase are subject to the general regime of legal remedies. There is another interesting point in relation to trial in absentia, slide number 14. Trial in absentia is possible in Spain in relation to confiscation with the following conditions. Direct confiscation, trial in absentia is possible where the unjustified absence of the defendant, who have been summoned personally, will is when the requested penalty is 2 years, is up to 2 years imprisonment, and 6 years when this penalty has a different nature. With this punishment threshold, the trial could be held if the person has been properly or legally summoned. Given that the penalties to be imposed to legal persons in Spain, as established in Article 33(7) of the Spanish Criminal Code, are lower than 6 years, the trial in absentia will also be possible against legal entities in general terms. As regards to the extended confiscation, we have also numerous clauses regime under Article 127 bis, and there you have the most serious EU crimes. Then the trial in absentia would not be ordinarily possible in general terms. If we move to the end up of the criminal liability, it's interesting to see that there is a provision in the Spanish Criminal Code that provides specifically that the transformation, merger, or absorption or spin-off of a legal entity does not extinguish its criminal liability to be extended and could be extended to the new resulting entity or entities. Then there is not an equal death of a natural person is not in cannot be compared to the ending up of a legal person, because this provision provides the possibility to extend the liability of a legal person to the new resultant entities. Also, there is a legal definition for the merely apparent dissolution of the legal person that not really extinguish the criminal liability, also to avoid this type of conducts of the 16 abuse of the legal regime of the existing legal system for legal persons. In relation to regulation 2018, in terms of trans-border recognition of freezing confiscation certificates, we have a different approach. As issuing authorities, Article 23, paragraph 2 of the regulation really make easier for the issuing authorities the issuing of a certificate legal persons in relation to legal person, as you can send it to any member state without or despite of the legal regime that they have in these member states in relation to the legal person's criminal liability. As executing state, in addition to the double criminality test that you normally have to apply under the regulation, Article 3, paragraph 2 of the regulation. In addition, we have to apply the basis of the equivalence principle and to assess whether is it possible to address the criminal proceedings at the national level to the legal person on the basis of a concrete offense included in the catalog that we have at a national level. Then this is also something that should be considered by the executing authority. At a practical level, we have detected at the International Cooperation Unit that a number of cases, there is a lack of Annex 1 of the 2018 regulation. Many authorities, judicial authorities, still send the Article 9 Annex of the 2003 framework decision. And in these cases, we just ask for the proper annex and the proper form in order to move forward. But we don't, we register it, we start with the digital file at this unit, but we ask via email for the replacement of the form and use the adequate Annex 1 of the regulation. We have also, from the formal approach, difficulties with the attachment of the relevant underlying freezing order, because Spain made a declaration. As you know, it's possible for the member states to make a declaration in order to ask for the relevant resolution, national decision, or a certified copy. And this, in a number of cases, we have also to ask for this resolution. It's not needed to send it translated into Spanish, but at least to have it as a formality, because in many of the cases we don't translate it internally. But we have to ask because the declaration is still in place. In those cases, as I told you before, we move forward. We don't stop. We don't suspend the the ongoing digital file, but normally we receive the proper certificate on the underlying judicial decision in a couple of days via email. Then it's not really a problem for complying with the concrete deadlines. We have a proposal for in relation to the 2018 regulation. If you look into the EGN website, in the legal instruments, you can find that there is a very nice handbook, but it's a handbook for judges, a prosecutor, and other competent authorities on how to issue and execute a request for enforcement of a freezing order in accordance with the framework decision, 2003 framework decision. I think it's urgent. It's a real need to replace this handbook with a new handbook, a handbook on how to use, to issue and execute a certificate issue under the new legal regime, under the new regulation. And this is just an example of how a new regulation 2018 is not an easy legal framework to deal with, as even we don't have even an updated handbook for practitioners in order to make the consultations that on daily basis we really need to make. And that's all from my side. Thank you very much for your attention, and I am also open to any questions in relation to the Spanish legal system.
Thank you so much, Francisco. I have two questions, but in relation to two aspects. The standard of the proof on the basis of this last judgment of the Supreme Court of 2024 is the prima facie evidence.
Yes, it is the prima facie, the circumstantial evidence. Yeah.
Yeah, but if we can translate in civil or criminal or I don't know, hybrid, no, the clear and evidence, it is a more civil. Prima facie, I think it is maybe less than the civil standard of the proof.
Is something in between. The Supreme Court decided that, well, presumption of innocence is not a principle to consider in relation to confiscation, as normally the national person has been already convicted, and then the culpability or the guilt of the person is not at stake. After the person has been convicted and the presumption of innocence is over, the court normally decide on the confiscation. And for the confiscation, mainly in order to establish the connection between the assets and the ownership of the assets and the criminal origin of these assets, the Supreme Court considered that prima facie indirect or circumstantial evidence is more than enough. And for that, they consider, and this is an example, a police report connecting the assets with the modus vivendi of the person who has been convicted, and the modus vivendi, of course, the criminal modus vivendi of this person. And there are also a list of presumptions in the criminal code in relation to extended confiscation that could be also applicable. Could be also a sort of guide for the courts.
Is it possible to apply this standard also for the non-conviction based confiscation? No?
Yes.
Decomiso sin sentenza. And so no, I have always some perplexities about this standard, and in particular when we speak to a confiscation against legal person with the consequences, no, loss of a job and so on. But another question is the confiscation which is included in the law of the liability of a legal person is also there is also the extended confiscation, or only like in the Italian system of law the direct confiscation. I mean, in the Italian system of law, the Article 19 of the Legislative Decree 231 of 2001 against of the liability, administrative liability against legal person include
Sorry, I think she's frozen. Yeah.
Yes, a problem.
Yes.
With internet
Yeah.
connection.
Yes.
Sorry, I think there is a problem. No?
Yes,
Yeah.
yes. With her internet connection, I think.
Yes.
But she was asking about extensive confiscation. Yeah.
Can you see me?
Yes. Yes. Now.
now.
Yeah.
Okay. Sorry, I have some problem
No,
with
no
the
worries.
connection.
You were asking about the
so-
confiscation, no?
Yeah, yes,
Yeah.
I would like to ask if in your system of law is there also the extended confiscation included in the law of about the liability for crimes of a legal person?
Well,
No.
extensive confiscation is applicable to natural persons, and of course,
Yes, sure.
this application is also impacting the assets of the legal persons involved.
Like in
But
Italy, but
in relation to extensive confiscation, it should be we have a double catalog system, because you have to see the catalog of offenses that are specifically provided for the criminal liability of legal persons. And also we have the catalog of the Euro crimes included in Article 128 bis for the extended confiscation. From my opinion, we have to also double check whether these two lists are in line and are a match. And then after this double check, you can apply double confiscation also to legal persons. But in principle, it's applicable to natural persons and impacting legal persons that are under natural persons that are under the remit of the legal person, acting on behalf, in the name, or under the...
yeah. So also in Italy, we can apply in the practice the extended confiscation against legal person when the owner is as this asset so on. What I ask if in the confiscation in your law about the liability of a legal person include also a specific form of extended confiscation.
No, articles that are related specifically to the criminal liability of legal persons do not have any reference to the extended confiscation. You have to go directly to Article 128. Yeah. And
Okay.
27, sorry. It's 27.
Yes,
Yeah.
like in the Italian system of law.
Yeah.
Yeah, it's the same. About this double check, I would like to better understand. So you mean that you have a check if the extended confiscation is included in the directive in order to guarantee the mutual recognition? Or, so can you repeat this aspect that is very important?
No, when we receive freezing or confiscation certificates, we have to double check first the list that is in the regulation, the 32 category of offenses list. After we have also to, if the only person that is in the certificate is a legal person, we have also to double check whether under the equivalence principle, this legal person should be also prosecuted in Spain.
For that crime?
For the crimes that are listed in our Spanish criminal code.
Okay. This is not included in the 32, in the list of the 32 crimes.
Yeah, but most of them, because we have more than 32 categories in the Spanish criminal code, most of them are there. Then there is no problem. I don't know any case that have been refused because under the equivalence principle, the legal person is not criminally prosecuted in Spain. But in theory, this is a possibility.
Yeah. Okay. Okay. Thank you. Thank you so much. Are there other issues?
Very welcome.
Okay. So now I give the floor to, sorry,
To Portugal.
Portugal. Okay.
Yeah.
Thank you so much, Malia.
Good morning. Good morning. Can you hear me?
Yeah.
Yeah. So
Sure.
good morning, everybody. Amalia, can you put my PowerPoint online?
I have already it. You can
Yes,
see.
yes.
Can you see that?
I see. Yes. Thank you.
Okay. Yes.
So good morning. Thank you for giving me the floor. I hope everybody is well and hearing me in perfect conditions. First of all, I have to say that for me it's a great honor and a privilege to be here and to have the opportunity to explain the Portuguese system regarding confiscation of legal persons. My presentation will be very short because our law is, if I can say so, a very good one. And once again, our problem is not law, but the praxis. Next slide, please. In Portugal, the confiscation of legal persons is almost equivalent to the confiscation of natural persons. If you know very well how it works with natural persons, you will know how it's going to work with legal persons, because it's almost, as I said, is almost the same. In fact, in 1982, I stress, in 1982, the Portuguese legislator introduced for the first time the criminal liability of legal persons in the law decree number 2884 that punishes crimes against the economy and the public health. After that, the Portuguese legislator also introduced the same concept in other kinds of crimes like tax fraud or direct dealing criminality. Finally, in 2007, the law 59/2007 introduced the criminal liability of legal persons in the criminal code. It's Article 11. For like the Spanish legislator, only for certain kinds of offenses, such as slavery, human beings trafficking, peeping, theft, burglary, embezzlement, forgery, pollution, criminal association, money laundering, corruption, and many others. I can say that almost all profit-driven crimes are included in this catalog. Next slide, please. Even if in the crimes foreseen in the Portuguese Criminal Code, next slide. No, before. Yes, this. In the crimes foreseen in the Portuguese Criminal Code and other legislation, as I said, legal persons and equivalent entities, with the exception of the state, other public legal persons and international organizations, are criminally responsible when the crime is committed in the name and in the collective interest of the legal person by a person who holds in it a leadership position, and whoever acting by whoever acting in the name or in behalf in his direct or indirect interest, under the authority of the person referred, the person referred in previous paragraph, by virtue of a branch of surveillance or control duties which are incumbent upon them. In all these cases, the legal entities is Spanish F is it was natural persons. So next slide. Whenever a legal person can be held accountable for committing a crime, they may also be confiscation of their own assets. We are speaking about the assets of the company because the company is held accountable for a crime. Of course, not all crime, because as we have already seen, not all crime are applicable, but most part of crimes are here applicable. Next slide, please. In all these cases, legal persons, the confiscation of the assets belonging to legal persons are the same of the confiscation of natural persons. So we can have direct confiscation of legal persons. We can have also value-based confiscation of legal persons. We can have unexplained wealth confiscation of legal persons, non-conviction based confiscation, and third parties confiscation of legal persons. As I said, the only difference is that natural persons are held accountable of all the crimes, and legal persons are held accountable of only of certain kinds of crimes foreseen in the penal code or other legislation. Next slide, please. The confiscation of shares or participations of a legal person does not raise any challenges and is admissible in Portugal without special reservations. Here we are speaking about the confiscation of natural persons that have shares on legal persons. However, in the practice, the confiscation of shares is considered not effective, since the company owners can devalue the legal person, for example, selling his assets, and in the end, the shares may worth nothing. A different issue is the confiscation of a company assets simply because the proprietor, a natural person, owns shares in that legal person. In such cases, regardless the confiscation of the shares with economic value, the assets held by the legal person can only be affected if it can be considered to be in bad faith, namely because the natural person accused or convicted exercised an exclusive influence of control over it. And this is normal. In this case, normally the legal person is in bad faith. So in Portugal, it is possible to confiscate the assets of a company if the company commits a crime, if the company is a beneficiary or a malafide third party. If the confiscated person owes something in the company, it is possible to confiscate his own assets, for instance, shares in the company. Next slide, please. So thank you for your attention. My colleague Hélio Rigor Rodrigues is online, and I give him the floor, if you allow me, because perhaps he wants to say something more. But it's very easy. It's like if we were confiscating the assets of a natural person.
Well, good morning to everybody. Well, I think that João already mentioned already managed to explain very well and very accurately how the Portuguese regime confiscation of legal persons works. Well, there are essentially, like João said, there are essentially two ways in which the assets belonging directly to legal persons can be confiscated. On one hand, we have the confiscation based on the criminal accountability or criminal liability of legal persons. And that's regardless their conviction. That means that it's possible in Portugal to confiscate the assets belonging to legal persons, regardless of their conviction, which means in all the non-conviction based confiscation possibilities that we have in Portugal. And that's not any difference between confiscation of legal persons and confiscation of natural persons. They have the same regime. And on the other hand, we have the possibility to confiscate the assets belonging to legal persons, because in the cases where the legal persons can be qualified or can be classified as a mala fide third party, as a company in bad faith. But in this case, and that's what I like to add, to what João just said, in that case, in the case where confiscation of legal persons is based on the fact that they can be considered mala fide third parties, we have here some differences with the regime of confiscation of natural persons. And that difference are based on the circumstance that the knowledge that the legal persons possess, it's the knowledge that the natural persons who control them have. So because legal persons mostly don't have any knowledge, don't know nothing. They just know what they owners, what the natural person that control them knows. And to this extension, even if it's possible, and in practice, the majority of the cases are based on this possibility, on the classification of legal person as a mala fide third party. And in these cases, the confiscation, and in this to this extent, the criterion used to determine whether a legal person is a mala fide third party or a company in bad faith to the purpose of confiscation, it will not be the knowledge or the obligation to know the source, the origins of the assets, but rather the existence of a decisive controlling influence of the natural persons who can be classified as a perpetrator or a mala fide third party himself. In essence, we follow here the same criterion that was present in the framework decision that Professor Malgeri speak in her presentation, the framework decision 212 from 2005, and that was subsequently followed in many legal instruments on this regard. Well, another thing that I like to add to what João said is that in most cases of confiscation of assets belonging to legal persons, what is at stake, what is at issue, is the use of that entity, that company, that legal person, as a mere means of removing the assets from the ownership of natural persons. Many times the legal persons are used not as a straw man, but as a straw thing, a straw company. And in these cases, like João already said, in practice, the solution will not be to confiscate or to seize or to freeze the shares or the participations that natural persons has on that legal person, but rather to confiscate or freeze or seize the assets that are owned or possessed by that owned or possessed directly by that legal person. This is because the mere confiscation or freezing of the shares does not, in many cases, in almost all cases, does not prevent the sale of the dissipation of the company's assets. So, in concluding, I think that we can say, regardless the possibility that the confiscation instruments can be used more widely in Portugal, we can say that in practice, we have many cases, a lot of them, where confiscation of assets belonging to legal persons has been enforced, has taken place. And so far, no big problems have been identified, regardless the confiscation occurs on the basis of the own criminal liability or own criminal accountability of the legal persons, or the confiscation occurs or enforced on the fact that the legal person can be qualified or identified as a malafide third party. Well, that's all I have to have, and I'm also at your disposal to any questions and any clarification that you think it's necessary from the Portuguese regime. And thank you very much for your attention.
Thank you so much. What I would like to ask is applied in the praxis, the different form of confiscation against legal person
Yes, it is.
with a good. Do you have statistic? Maybe
This is the problem. As you know, we don't have reliable statistics. But as far as I know, and I think as far as Elio knows, I don't know if he wants to add something.
Okay.
It's applied in the praxis, of course.
Okay.
Yes.
Of course. Sometimes we have in a decision we have the confiscation of a natural person and also the confiscation of a legal person because they both committed a crime.
Yeah, and just to add something to what João said, in practice that occurs very frequently, and what happens is that when at the same time we have criminal liability of the legal person and criminal liability of the natural person, with regard to confiscation, what happens in the decision when the court convicts the legal person and the natural person, it's that regard to confiscation, what is stated is that the values or the confiscation will be enforced by the obligation that legal person and natural person can pay with the solidarity regime the value of confiscation that is decided by the court when the conviction is based on the value-based confiscation. So if even that
because if it's a value confiscation.
If it will be value, in most cases, like I don't know the percentage, but in almost all cases, it's value-based confiscation. I think it's more than 90%. And in that cases, the legal person and the natural person will be convicted to pay on basis of the solidarity regime the amount that the court establishes should be confiscated. And we also have case law on that regard. So that's a lot of case law on the confiscation of legal persons.
But
mainly
with the limit of the amount of the proceeds.
Of
exactly.
course.
Yeah.
But because in Italy we have some only rarely in some judgment there is this idea that in Italy we speak about this, no? The confiscation of the value is considered a punishment. So in some rare judgment it is affirmed that the punishment has to be applied against each partner in the crime. So this means against for the total amount against each of the perpetrator, also in when there is the complicity, and against also legal person. So in this case, the confiscation is not a confiscation of the proceeds, but is a real patrimonial sanction, no? Punishment is, and there is many issue about the respect of the principle of proportionality and so on. But there is also another approach that it is possible to apply, and this is the more common approach. It is possible to apply the seizure, the freezing order, against each either better and so also against the legal person when it is in any case the beneficiary of the proceeds, and even if the confiscation is only in the limit of the amount of the proceeds. But in any case, to apply for the total amount of the proceeds, the seizure against each against legal person and the natural person has an invasive, afflictive effect, no? Because the seizure in some cases is possible, no, to confirm for many years also, no, and it is the consequences for a legal person are real, no, very very negative, no, to the seizure for. But this is the common approach, no. This is problematic. This is this idea of solidarity, no?
But in our case, we have to take out of the criminals what they won with the crime, not more than that. So if they if the natural person and the legal person won 1 million, we have to take 1 million, no matter who.
In Italy, when it is not possible to understand who is the beneficiary, who has the money, it's possible to apply the seizure, not it's only rare judgment, the confiscation, but the seizure is more common. The seizure for 1 million to each to natural person and to legal person, and to if the natural person are there are the header arbiter, no, for each perpetrator or each either an arbiter of the crime. So it is possible that this multiplication of a seizure in order to avoid the dispersion of it. This is, yeah, in my opinion, is a real afflictive effect, but it is more common in the Italian case law.
Yeah, but the Portuguese solution is
sorry, I lost my connection.
The connection. Yeah, I was just mentioned to conclude that the Portuguese rationale behind that solution that we enforce is that if 5 people committed a crime, regardless they are legal or natural persons, if 5 persons committed a crime and they obtain proceeds of €1 million, that the same 5 people within the solidarity regime need to pay that €1 million, and that we don't know how they split their proceeds, and that's the rationale behind the Portuguese solution. They all together need to pay €1 million. That doesn't mean they need to pay €1 million each. They just need together with the solidarity regime to pay €1 million. If one of them have money enough, that will pay, and the others can make the accountability with him later. We do not multiplicate that 1 million per 5. Is the limit is the amount of the proceeds that had been obtained.
Also for the seizure.
and also for the seizure. Yeah, it needs to be proportional. The seizure and freezing needs to be proportional to the value of the confiscation that we need to ensure with that. So it's the same. We do not multiplicate or replicate the accountability or the liability on the value of the confiscation. The value is limited by the amount of the proceeds that specific crime generated in that case.
Yeah, but if it is not clear who has the money, is it possible to apply only against, for example, legal person? So because in Italy there is this also this rule. Somebody has asked that is when it is not clear. But this is the problem. No, it's not clear who has the money. So is possible, for example, to apply for the total amount against legal person, even if we don't know if the money, the natural person has the money or the legal person. This is so also in Portugal?
Yes.
Okay.
Yeah.
Is there a question? An issue? Question?
Yes, Anna Segelaragi has asked to speak. Anna,
please.
Yeah, hi everybody. Thank you for the presentation. I have just one question. The point that you mentioned. Can you hear me?
Yes, here, but not see.
But some cuts. Yeah.
Let's see now. Yeah, it should work now.
Okay.
Hi.
Hi.
So the question is in the point that you mentioned of the decisive controlling influence. So if we have the organ shareholder of the company and he or she has this decisive controlling influence on the company, however, if I understand it well, in Portugal, you confiscate the assets directly from the company and not from the private person, not from the natural person.
I'm sorry, I hear with some cuts. I think that you ask about the criteria. I don't know if I hear anything. Probably it's my network that doesn't work very well. I hear with some cuts, with some interruptions. But I think that you ask about the criterion that I mentioned that is used to define a legal person as a malafide third party, right? The possibility of the legal person control exclusively or mainly the legal person. It was about that, I think, right?
I don't know if I'm the only one. I cannot hear the answer. Sorry.
No, I was just asking because I hear with some interruptions, with some cuts. I think that your question was about the criterion that I mentioned that was used to qualify a legal person as a malafide third party. It was about that, or was something else? I don't know if I hear it.
He's not hearing you.
Anna, can you hear? Can you hear?
No.
Anna?
She's not hearing.
Yes, I suppose. This is the problem of online meeting.
Yes.
It is better in presence.
And today we are having lots of problems.
Anna is okay? No.
Perhaps after she can
Yes,
again.
maybe she maybe can. Yeah. So are there some other issue for Joao or Elio? Sorry, I would like to come back to Francisco for a question issue. Francisco, do you speak about the application of the principle of proportionality in relation to confiscation against legal person? Yes, sure. In consideration of the liability, of the seriousness of the liability, but this is the question. Okay, if we speak of the principle of proportionality in general, okay, we can apply to confiscation. But if we speak about the principle of proportionality in relation with the measure of the amounts to confiscate, this principle of proportionality of commiseration between the seriousness of the crime of the liability and the measure of the value of the assets to confiscate. I think that we can't apply this principle in relation to form of confiscation which are not considered punishment, because the principle of the proportionality in stricto sensu, proportionality between the measure of the sanction and the measure of the seriousness of the liability of the crime is possible to apply only for a punishment, a sanction, or do you have another opinion? Can you better explain the application of the principle of proportionality in relation to confiscation?
Well,
In your system of law, in this
yes.
case.
Let me, well, we have a general rule in Article 128, and it is applicable to both, of course, natural and legal persons. This provision allows the court, the judicial authorities, to decide on proportionality basis about confiscation of assets and instrumentalities of legal trade, considering mainly the nature and the seriousness of the criminal offense at stake, and also whether the civil compensation owed by the victim has been fully satisfied, in general terms. But in relation to legal persons, there is a particular provision in Article 31 ter, is the article in paragraph 1 of the Spanish Criminal Code that provides a very peculiar proportionality clause whenever fines are handed down to both natural and legal persons. According to this article, when natural and legal persons have been punished with a fine, with a financial sanction, as a consequence of the committed criminal offenses, the court shall, and it's mandatory, modulate, compensate the respective amounts. So the resulting sum is not disproportionate in relation to the seriousness of such offenses. And this is important because fines are the national, so-called national penalties to be imposed to legal persons. Then, as penalties are imposed both to national persons and to legal persons in relation, when we are speaking about fines, this compensation is also a sign of the application of proportionality principles to legal persons. I don't know if this answers your question.
Yeah, okay. No, I can better understand with, okay, when we speak over the confiscation of the instruments, that is also a form of punishment, no? Because the instruments are can be legal of legal origin. So there is also an afflictive meaning, so the principle of proportionality is possible to apply in a strict sense. Maybe for the confiscation of the proceeds, the problem is that in some cases, if you apply the fine and also the confiscation of the proceeds, in particular for legal person, the effect, the consequences too not disproportionate in strict sensu, but too afflictive, or also with consequences for the economic activity. So in no in strict sense, no, because if it is the proceeds of the crime, you can't get it, no, you can't maintain the property. But in some cases, the effect can be so afflictive for the economic activity, to carry on the economic activity, that it is better to apply this principle in order to avoid the in German law, Anna, there is a word, strangle, no, I don't remember in English, the effect to compromise the life, no? Over the,
But same can happen.
yes.
Yeah.
Sorry,
this is
same can happen with a natural person. Also, the life of a natural person can be in danger in this case.
Yeah.
So, and also in Portugal, of course, there is also when the life is at stake, the meaning for a normal life. In this case, perhaps we can have some measures, but this kind of measures is not when, at least in Portuguese system, is not when the judges decide. It's after that, when we are executing the confiscation order, or when we are executing the penalty, then we can have this in mind, but not before.
Yes, in relation to this, I guess that your question is linked to the administration of companies, no, the intervention of companies. In relation to this measure, there is also a provision in the same article, in Article 33, in the last paragraph, that the intervention may affect the whole organization or be limited to some of the premises of the organization, a concrete section or a business unit. And the court shall, in these cases, tailor-made the decision and determine exactly the content of the intervention, and shall also be very concrete on who shall take the charge of the intervention, and within which particular monitoring report this must be, well, the legal person is obliged to submit a concrete monitoring report to the judicial body on regular basis in order to keep the sanction or keep the measure or lift it if the company is complying with the rules that have been established in the judicial decision. The intervention may be modified or suspended at any time. This flexibility shows that the proportionality clause is in place. This is for the administration of companies. In order to make it work and to not to put it in a risk the employees and the workers of the company. I don't know if this the question is
this is
your question, but it's also provided
the criminal
in the law.
liability.
Sorry,
is it possible to apply this measure when there is the criminal liability?
The crime
or the legal the criminal liability, the conviction of the
yes,
legal person.
It is.
Yes.
Yeah.
Okay. This is interesting. Okay. So I suppose
there is a distinction between Article 33 and Article 129, because 129 is the application of a temporary closure or precautionary measure. Then, but it could be also imposed in the final sentence, and also to be modulated during the execution phase.
Okay, thank you. Okay, so I suppose that we can make a pause. Maybe a quarter, 15 or 20 minutes?
Yes, not more.
Yes,
20 minutes.
no more. Okay, 20 minutes. So,
So 10 minutes past 12.
Okay, 10 past 12. Okay. See you later.
See you later.
Sorry, I was speaking about you couldn't hear me. Okay, now
Lithuania.
Lithuania. Okay, now Lithuania. Netherlands in the afternoon. Now Lithuania. Okay, I give you the floor, please. Lithuania.
We can hear you, Mrs. Jurata. We can hear you. We cannot hear you. No, not yet.
No.
Okay, the microphone appears to be opened, but we cannot hear you.
So we can start Poland.
Yes, Polonia wrote to me that they have some technical problem and they asked to reschedule their presentation. I don't know if they are here and if they have just solved their problems. The partner from Polonia.
And in any case,
however, they aren't here, but we have an Abby, Edward. So maybe Edward is ready.
Hello.
Okay, we can
Here.
start with Romania. Okay. And I
Okay.
hope that in meantime the other can solve the problem.
Okay, Amalia, please help me.
Yes, I have to change the presentation because I had that one of Lithuania.
I can't see. Now it's okay.
Okay.
The second slide.
Yes.
So, as in Portugal, in Romania, we have the same system for legal person as for individual person, as a physical person. So we have two types of confiscation, the special confiscation and the extended confiscation, as I presented in the first of our workshops. Both types of confiscation can be applied to third parties. Special confiscation can also be applied in the absence of the conviction, non-conviction based confiscation, while extended confiscation can only be applied as part of a conviction and after conviction. To sum up, in Romania, we have special confiscation corresponds to direct confiscation, confiscation by equivalent, confiscation against third parties, and non-conviction based confiscation, while extended confiscation can be ordered both against the convicted person and third parties. The same system is also for legal person. The legal regime of special confiscation and extended confiscation is regulated in our criminal code. There are both security measures. According to the criminal code, the scope of security measures is to remove the state of danger and to prevent crimes from being committed. Although these measures are intrusive to the right of the person, they are not considered criminal sanctions. The next slide. The confiscation applicable against the legal person. In Romania, the confiscation models applied to natural persons are also applied to legal person. I already said it. There is no distinct legal regime in this matter. Thus, if the legal entity is targeted by the criminal investigation, its asset can be confiscated, special or extended confiscation. Additionally, the provision on freezing order are applicable under the same condition to both individuals and legal entities. We can have some relation between, of course, the legal person and the natural person. A confiscation order against the natural person may affect a legal person, although the legal person was not involved in the commission of the crime. For example, the shares owned by the natural person can be confiscated, special confiscation, in the situation where they are obtained from sums that represent the proceeds of crime. Also, if assets of the legal entity were used and it knew the purpose of which they were used, the assets of the legal entity can be confiscated as a special confiscation from a third party. At the same time, the shares held by convicted natural person can be also extensively confiscated. In conclusion, the shares held by a natural person have the legal nature of an asset, and if the condition of a special or extended confiscation in relation to the owner are met, they can be confiscated from the owner. We have a special provision for liability of legal entities under Article 135. So legal entities, except the state and public authorities, shall have criminal liability for offenses committed in the performance of the object of activity of legal entities or in their interest or behalf. Public institutions shall not be held criminal liability for offenses committed in the performance of activities that cannot be object of the private domain. Criminal liability of legal entities does not exclude the criminal liability of the individual participating in the commission of the same act. So we have a parallel with a natural person. At Article 136, the provisions are about the penalties applicable to a legal person, which are the double one, to say so. The principal penalty shall be a fine, and the complementary penalties are dissolution of the legal person, suspension of the activity or one of the activities of the legal person for a period of 3 months to 3 years, closure of some of the legal person places of business for a period of between 3 months and 2 years, prohibition to participate in public procurement procedures for a period of 1 to 3 years, placing under judicial supervision, and notification of publication of the judgment of conviction. So this is how the legal person can respond in our criminal courts. Also, in the time of the criminal procedure, we have preventive measures against legal persons. The judge of right and freedom during the criminal proceeding, on the proposal of the public prosecutor, or in the case may be the preliminary chamber judge or the court. So this measure can be instituted only by the judges. If there are reasonable grounds justifying the reasonable suspicion that the legal person has committed an offense provided for by the criminal law, and only in order to ensure the proper conduct of the criminal proceedings, one of or more preventive measures can be taken. And I will present the preventive measures. There is another slide, 9. There are 5. Prohibition of the initiation of suspension of proceedings for the dissolution or liquidation of the legal person in order to prevent the disappearance, in order to avoid criminal and often civil liability. So the prohibition to initiating or suspending the proceeding to dissolution. This is the first case we want to prevent. Prohibition of the initiation on or suspension of the merge, division, or reduction of the share capital of the legal person initiated before or during criminal proceedings in order to prevent the disappearance or reduction of the legal person in order to avoid liability. prohibition of certain assets operation in order to prevent significant reduction of the asset of insolvency of the legal person, prohibition of the conclusion of certain legal acts established by the judicial body, and prohibition to carry out activities of the nature of those during which the offense was committed. I will present some cases from the European Court of Justice, from Supreme Court, in which Romania was part. The European Justice, we had a significant case, Credit Europe Leasing IFN SA, which is a legal person against Romania. The court emphasized that Article 1, Protocol 1, number 1 to the European Convention contained 3 distinct rules. It observed that the seizure of the assets constituted an interference in the existence of the right of property of the complainant company because the measure was maintained almost 9 years, which it was a confiscation de facto. Because it was too long, a seizure for 9 years. In conclusion, the European Court found that the violation against Article 1, Protocol 1, highlighting the need for a fair balance between measures taken in the public interest, like seizure, and the protection of the fundamental rights of individuals and legal entities. This is one of the most important cases the European courts with a legal person in against Romania. The next one, it's a decision from our Supreme Court which regulates some provisions. So the existence of security measures, freezing measures, established in the course of criminal proceedings of the assets of a legal person prior to the opening of insolvency proceedings with a view to special confiscation compensation for the damage caused by the offense or guaranteeing the execution of legal costs, do not suspend the liquidation procedure with regard to seized property, and do not prevent the liquidation of the property carried out by the judicial liquidator in the exercise of the powers conferred. So the freezing measure can block, the civil circuit. If the person can, the legal person cannot sell or dispose that good, but if other creditors are executing that goods, even if it is a liquidation activity, liquidation activity, they can liquidate the assets, even if there is freezing measures about them. So this is the optic of our Supreme Court, that the freezing measure can block the civil execution from other creditors. The next one, about statistical data, I already observed that neither other countries have good statistical data on this issue. At the moment, we don't have a statistical data on the application of confiscation measures against legal person at national level. As we already said in our presentations, Romania is currently implementing a unique electronic register called ROARMIS, Romanian Asset Recovery and Management Integrated System. The system is managed from my institution here in Anabi, which is the ARO and AMO office, Asset Recovery Office and Asset Management Office in Romania, is the national centralized institution. This system will contain real-time data of the freezing and confiscation orders. In addition, the system provides for efficient management of freezing assets. At the same time, the system will make it easier to identify assets that have been made frozen or confiscated following the recognition procedure in the regulation, as it will be function to identify files with an element of extraneous. In the future, with the adequate filling of the data by all the authorities involved, courts, prosecutors, office, police, tax enforcement bodies, will be able to generate relevant statistics, including a comparative analysis between confiscation measures ordered in relation to natural and legal person. So from the beginning of 2024, we will try to introduce data in this system and all the authorities, but we cannot introduce the data from behind 2010 or maybe from another time. We'll need to have a start point, and this will be 1st of January 2025. Statistical data on the application of confiscation measures against a legal person at national level, which are not about confiscation, it's about freezing, because our prosecutors' offices, they only have the freezing measures in their competence. Number of freezing orders concerning legal persons sent to other member states which have been recognized and executed was 3 in the base of regulation, to Hungary, Bulgaria, and the Netherlands. And all 3 was about bank accounts. Number of freezing orders concerning legal persons sent to other members which were refused recognition and execution was 1 from Poland. The bank account of the legal entity targeted by the freezing order was already seized in the national file. The execution was not actually refused, but the amount of money was not returned. The freezing was requested in order to return it to the victim. But the case is it's in the court now, and maybe after final conviction, we'll receive some money from that account. Number of freezing orders concerning legal person received from other member states which have been recognized and executed, including type of confiscation. Yes, our prosecutor's office didn't mention the type of confiscation. We asked them that, but they only transmitted us only the numbers: freezing bank accounts, 42, as you can see. Number of freezing order concerning legal person received from other member states which have been refused. 2 for France, the assets targeted in Romania by the freezing order did not belong to the investigated persons, and there was not other information to make a link between these persons and the assets. And 1 from Italy, as you know, it is a problem in Romania with the concept in criminal matters. I don't know very well the file because it's on criminal investigation. Maybe after it will be on court, I will find maybe other information in court in Italy. So,
do you remember which kind of confiscation was
no,
involved in this case?
they didn't mention, but they inform us that following the analysis of national, international, and the European jurisprudence, it turned out that the procedure that's granting the freezing order could be considered in criminal matters. Is the old problem with this notion
Okay.
in regulation.
Sorry if I interrupt you. Can you, after the next day, try to understand, to know exactly which kind of form of Italian confiscation is this involved in this case, in order to better understand the problems?
I will try to contact my colleagues from
Yeah. Thank you so much.
Next slide.
And also for France, it will be interesting to understand.
Yes, in France, I think in France was a lack of information there.
Yeah.
Maybe France needed to put more information to
Yeah,
make
maybe it
win.
was a beneficiary of the process of the climate. Yes.
Proposal
Okay.
of harmonization of member states legislation, also in considering of the new proposal. I want to say that I already said I was at direct negotiation at the directive. In its original form, at the Article 11, paragraph 7, was a special provision where the property to be frozen consists the entities that should be preserved as a going concern, exact the management of a legal person. That it is. Such an undertakings, the freezing order shall include measure to exclude access to this property by the person owning or controlling them while allowing for continued operation. This provision was removed following the negotiation from the directive at Brussels. However, we appreciate that such a proposal will have been very, very useful. Also, I want to say the Eurojust from Romania, representative from Romania, told me that it were a very good proposal, but we don't have it, especially in the context in which all member states should have to regulate instruments to ensure that management of companies in the situation where the parts would have been seized. In Romania, we don't have this type of management of the shares, but maybe in the future we have some situation where we sell it as a evaluatory preventive selling. We sold some shares, but not management them. The next one. We believe that it will be appropriate to regulate the manner of administration of the seeds shares. In this sense, we consider that the seeds shares should be administered like in Italy, as we already know, by an insolvency practitioner. It's in Romania, a specialist who is checked. In our opinion, it needs to be checked by a specialized insolvency court, not by criminal court, because, for example, I'm a civil judge. I can understand how to manage a company, I think, better than a criminal judge who need to know better criminal aspects, know how to control a society, a legal person. And the last slide. Possible guidelines of the practical implementation of the regulation regarding the use of this tool by Romanian practitioner. We appreciate that it's necessary to intensify the training activities to achieve a better knowledge of the concrete steps to follow, the identification of the assets belonging to the legal entities in question located abroad, respectively the practical way to use the cooperation tool, issuing the order, filling the form, sending the documents to the executing state. Also, especially in the case of investigative bodies, it is absolutely necessary to use a specific tool in this matter, such as addressing to Asset Recovery Office, through which useful financial information could be obtained prior to the time of using the procedure. I think in our next workshop, we'll discuss more about asset recovery offices and about the information that can be exchanged in between these asset recovery offices from the Europe. That's all. Thank you.
Okay. Thank you so much. And issue by me, if I would like to better understand the liability, the criminal liability of a legal person is provided for each crime also only for some specific crimes?
They are for each crime that is possible to be done by a legal person.
Okay, and in
Some
this,
cannot be done by a legal person.
okay, and another, and after I give the floor to Jean-Lise. But in that case, in front of the European Court of Human Rights, the problem was that the schedule was too long, for too much time.
Yes.
Okay. Yes, in the last, also in another case, it's a bit different, no? In the Dimitrov case, the problem was also that this even if it was in a different perspective, there was not the European Court of Human Rights in the Dimitrov case against Bulgarian. The problem of the time was in the meaning that the proceeding of confiscation was after a lot of time in relation to the crime. No, in the case, the court said that could yes, that it could not lapse through prescription, which means that the individuals being investigated and it could be required to provide evidence of the income they had received and they expenditure many years earlier and without any reasonable limitation in time. No, this is another perspective in relation with the time, no, but and also in the Todorov case, there is also this issue about the respect of the principle of proportionality in relation over the time. If I exactly remember. So there is in my opinion, in the case law of the European Court of Human Rights, in the last time also this attention of the principle of proportionality also in consideration of the problem of the time. And it is interesting. Can you send me or send us to the Recover network this judgment of the European Court of Human Rights? Because this, I suppose that this is also a problem in Italy and in other member states, that sometimes the schedule is too long, doesn't guarantee the respect of the principle of proportionality on this approach, on this point of view. Jean-Lise, please.
Yes, I would like to have a short response on the remark the Romanian colleague made about the new confiscation directive in Article 11 passage that was removed about the going concern.
Recital, this is the recital,
yes.
No? Yeah.
Yes, because
I don't remember.
Because in the text that now is agreed upon between the Parliament and the Commission, in the articles about asset management and planning, there is an article that's a paragraph that now says that the member states shall adopt appropriate measures to ensure that the efficient management of entities that should be preserved as going concern, such as undertakings. So that some passage has returned in the directive.
Yes, yeah. I know, because they transmit I already received that, but I don't know if it will be in the end of the final act.
It will, because the text won't change anymore.
Ah, okay. I'm glad to be.
No, it is. No, it would be interesting to understand because it is better in the rule, no, in comparison with in the recital. because the recital, okay, it is important in the interpretation, in the there are directives, but in any case, it's not so mandatory, no, in some way, in comparison with it would be interesting to understand why in the recital and no in the specifically in the rule, no.
Yeah, I could maybe clarify a bit from the Dutch perspective, because we don't freeze going concern undertakings. So from the Dutch perspective, we would have preferred a recital, because we don't want to be obliged to freeze going concern undertakings.
Okay, okay. So it's clear. Okay. Are there other issues? Question? No? Okay. So thank you so much, and we can
Maybe
carry
we
on
can try with Mrs.
Poland. Ah, no,
Oh,
Lithuania. Okay,
Lithuania.
Lithuania.
Yes. We can try once more.
Yeah, maybe we can.
No, we cannot
Jurate.
hear yet. No, we cannot hear yet.
It's strange because we can see her. Maybe she has to change the.
You have tried to go out from the meeting and then to get in once more?
Okay. Okay, Poland.
No,
Oh,
Poland
no.
isn't here.
No?
No, I think maybe they want to postpone in the
Jurate?
afternoon. No.
Maybe can you try with another computer or also with mobile, I don't know, in order to speak. So we can maybe see you with through computer and hear you through the mobile. After okay, after we have Netherlands. Okay. We verify if Jurate can solve a minute, and otherwise we carry on with Robert and the Netherlands. No?
Yes, we can start with the Netherlands if you want to.
Yes.
Amalia, can you open our slides?
Yes, just a second. Can you see it?
Yes, I can see it.
Okay.
Maybe you can go to the second one, please. As you can see, this is not a very long presentation, because as we will see, the situation for legal persons in the Netherlands is comparable with that to natural persons. But I will touch some special topics in this project regarding legal persons. Maybe you can go to the next slide. In Article 51 of our Criminal Code, legal persons, according to our Article 51, legal persons can commit crimes but it's not the only one who can be prosecuted. Also, natural persons can be prosecuted for the crimes committed by legal persons. Not all natural persons can be prosecuted, but it's got to do with people who ordered the criminal offense or actually directed the criminal offense. We can prosecute, if we want to, both of them, as well as the legal person as the natural person. And it depends on the case whether the prosecutor will decide whether to prosecute a legal person or not. For example, when it's a big company with a lot of legal activities, it's likely that the company will be prosecuted. It has a lot of assets, so the company can be punished. But sometimes a company is only used for as an instrument of crime, and it has no assets, and then we have to ask ourselves the question whether it's necessary to prosecute a legal person, especially when there are no assets. We don't see often that a prosecution is necessary or useful. It might be useful, for example, when there are licensed activities in a company, and a conviction is useful to withdraw a license. Maybe we can go to the next slide. In our Dutch law, it's important to understand that we have different legal persons. We have the civil legal persons and the administrative legal persons. One of them is the state as a national legal person. We also have other legal persons like local authorities or provinces. The state cannot be criminally be prosecuted. That is something between the minister and the parliament. Lower legal persons can be prosecuted criminally, but we don't see it that often. Maybe we can go to the next slide. Oh, I can say that individual officials of the government can be prosecuted for the crimes they commit. As I said, all models of legal persons can be compared with natural persons when we want to prosecute them. So all the models of confiscation are possible with legal persons as well. Now I want to focus on two of them, the value confiscation measure and the skimming fine. So please, the next slide. Our principle is that the deprivation and confiscation orders are given to persons who actually gained the proceeds of crime. But we see that sometimes legal persons do not exist any longer and they cannot be prosecuted. And then, of course, it's interesting to see what we can do then. And in certain cases, we can say that the illegal profits of the legal person can be imputed to the natural person who actually directed the unlawful acts. That's not in all cases possible. There are a few conditions. The first one is that the natural person or a legal person substantially controls the legal person. The second one is that this natural or legal person had the power of disposal of the assets of the legal person, and the benefit obtained by the legal person was able to benefit the natural or legal person. In that case, we can say that although maybe the natural person didn't gain any profit from the crime, he can be held accountable for the proceeds of the legal person. and therefore we can freeze his assets as well. Because the legal person doesn't have to exist any longer, and conviction of the legal person in that case is not necessary. Next slide, please. Then we have the skimming fine or just a fine. Sometimes the profits or the fine is not high enough because we have categories in our criminal code, and under certain conditions, when we say this is not appropriate, we can go to the next higher category. So when a company, a legal person, commits a crime of the 5th category, usually it's up to a maximum fine of 103,000 euros. When it's not appropriate, the court can say we give you a fine of the 6th category, and that's up to more than 1 million. And when that is not even enough, we can go to up to 10%, a maximum of 10% of the annual turnover. This can be used as a skimming fine as well, and therefore it's a kind of confiscation. And next slide, please. This is not criminal law, but we have our own civil law lawyers in our public prosecution service. And that is because the public prosecutor has civil competences as well. He can request, for example, the court for the dissolution of a legal entity. And during this process, it's possible that directors may be suspended. And after this dissolution, a neutral third party is appointed by the court as a liquidator, and the court can rule that after the legal entity was declared prohibited, that the assets will go to the state. This also is possible with foundations. We can request the suspension and dismissal of directors. And we had a very big case during the COVID crisis. There was a former politician, and he told the government that he was able to provide face masks, and he offered his services non-profit. But in the end, it looked like the face masks were delivered through a foundation, but actually it was another legal entity, and he earned a lot of money with it. And he is a suspect of embezzlement. And next to the criminal procedure, a civil procedure was started. And in this procedure, he was dismissed by the court. And now there are liquidators. And they're trying to get the money back from him in cooperation with the public prosecutor. In bankruptcy cases, the public prosecutor can always conclude in the civil procedure. So sometimes we see that our criminals request the court to be called bankrupt, but we know that the only claims in the company are claims of other criminals. So this means that when they go bankrupt, we have to lift the freezing, and the freezing is used. The assets are used to pay the parties with claims. And in that case, we sometimes conclude at the court, like, this is only a fake construction, a fake bankruptcy to have us lifted the balances and the freezings on other assets. So actually, it's not really very different compared to legal persons, to natural persons. And because there's no difference, extended confiscation is possible, a third-party confiscation is possible as well. I think this is it in short in the Netherlands regarding legal persons.
Okay. So, is it applied in the practice confiscation against legal person?
Yes, it does, but it doesn't happen a lot because often the legal persons are the instruments for the crime, and there are no assets in it. So we prosecute the natural persons because then they got a conviction, and sometimes they are not allowed to have a new legal person on their name again. And this is more useful than us than prosecuting a legal person because, well, then the director can just start as a new shareholder, a new company, and that's actually what we don't want to.
Okay. But when the legal, the confiscation is applied against legal person, are there problem of management of the legal person? Because, okay, you have this civil competence, also this proceeding for the dissolution and so on. But when I would like to understand, first of all, when is it possible to apply this dissolution, which is a consequence of the crime, is a kind of a civil punishment?
No, well, when we have started the criminal proceedings against the legal person before the dissolution, we can continue with the criminal proceedings.
Okay.
Maybe that's a bit strange because legally it might be dead, the legal person, but when we started before the death of the legal person, we can continue.
Okay. Ma when you decide, which are why the dissolution? When it's not possible, is I haven't understood which are the condition in order to apply the dissolution. Is an economic issue that the company is not able to carry on the economic activity, or is it a kind of consequence of the crime?
For example, we use this with the outlaw motorcycle gangs. We want them to be prohibited. We can start a criminal procedure against the members as a member of a criminal organization or their own individual criminal offenses. At the same time, we can start a dissemination procedure and to have that's a civil procedure, and also to have the legal person prohibited by the court. And when this is happening, the motorcycle gang, all the assets of the gang will be transferred, lapsed to the state.
Yeah, but this is not a real, is a real enterprise, is a real business.
It doesn't have to be also. It's in our report, but I think it's too deep in stuff for this presentation.
Yeah.
It doesn't necessarily have to be a legal person as mentioned in the registry in the chamber.
Yeah. The same in Italy, but in any case, you have to have a business, no? Economic activity. In this case, or the motor.
No, they don't have any illegal activities. That's true.
Yeah.
But sometimes we see like other companies with a straw man, they're only used for criminal activities, for money laundering, etc.
Yeah. Okay.
And with fake administration, etc., just to
money laundering. Yeah.
Yeah, for some kind of legal background, at least.
Okay. So also in Italy we have a rule that is in the law for the administrative liability for crimes. It is possible a kind of dissolution of the enterprise, of the business, when it is destined to criminal activity. But it has to be the main purpose, the main activity, no? The illegal activity. So, yes, okay. Are there other questions? Is everything is clear? No doubts? Okay. Because in Italy we have this problem, no? That when corporation is or a corporation enterprise is confiscated in many cases, in the most case, the solution is the liquidation. The business is not able to carry on. Okay, in some cases we have a very good results, but in other cases is the liquidation. Do you have this kind of experience? Not as
Well, it depends.
civil.
Sometimes we see that a company is only alive for committing crimes.
Yeah.
And what we can do is seize everything. Of course, this disrupts the ongoing concern, but when a company is only used for crimes or mainly used, for example, 80% of the economic activities is illegal, then it's not necessary to have an ongoing concern, because the ongoing concern is only 20% of the total. So then we freeze everything, and well, in the end, the bank, the legal company will go bankrupt. But that's not really a problem, because it's only used for illegal activities. Is this an answer to your question?
Yes, yes. The problem is that sometimes they are not so involved in the crime, the legal person, the enterprise. No, and sometimes we have also another problem that after the seizure, the legal person, the court decided that it is not possible to apply the confiscation because there are not the elements to apply the confiscation. But after the seizure, for many years or for some years, the enterprise is not more able to carry on its activity. For example, in a case, for a company, a corporation in Palermo, in Sicily, the owner had 15 shops that works very well. After the seizure, the court didn't apply the confiscation because it was demonstrated that the owner was not involved in criminal activity. And the first element, the suspicion, was based on the fact that one of the employer was connected, was a familiar of a mafia family. But this was the only element. But after the seizure, this kind of company, no, with 15 shops, which worked very well, in the end was completely compromised. So it is no, in some cases the problem, no, because it is prima facie, it is aspect sufficient circumstantial evidence. It is possible to start, no, with seizure. But after, it is difficult to guarantee the problem, no? Avoid that the owner carry on to manage the activity during the seizure, but in sometimes also because a new judicial administrator is not able to manage, to deal the economic activity, the result is that even if when there are not the condition to apply the confiscation, the economic activity is not illegal, the result is that the economic activity is real compromised, no? It's not, this is...
Well, I know maybe something maybe you can compare this with the case we had in the Netherlands. It was about fertilizer, and the administration of the company was partly false. And there was an investigation started, and they had proceeds of crime. So all the assets of the company were frozen, including all their trucks. But because the company had an ongoing concern in the season, they were told that they were keepers of the frozen cars. So they could use their cars, only they were not able to sell it, etc.
Yeah.
So they could still perform their activities, but in the end, everything was frozen. Yeah. So there are possibilities, but we also see other things, like we have language schools for people who come from abroad and they have to learn the Dutch language. They are provided with a sum of money and they can choose the language schools themselves. And there's a lot of fraud involved in that. And we say that, well, maybe 40% is legal and the other 60% of money that comes into the company is illegal, because they tell people, come and join us for a language course. We'll provide you with a certificate, but in the end, those people don't follow the course. Maybe they get even an amount or a bonus card from the company, because actually they provide a lot of money. And then the court has to deal with, well, is everything illicit now? Because there's a lot of money in the bank account with legal money, and they mix the legal and the illegal money. Everything is mixing together. But in the end, in those companies, we freeze all the assets of the company. And that's a problem for the ongoing concern. But we know that a lot of money will go abroad, and that when we don't freeze everything, we'll even get less when we have a confiscation order. Because they have a fraud for 100%, we freeze maybe 30%, and when we have to freeze less, we have only 20%. And with the 30%, it's not even the 100%. So we try to freeze as much as possible.
Yeah. Okay, thank you so much. So, Jurate hasn't solved the problem, and we can carry on.
Yes, maybe with Bulgaria, because Poland isn't still here. Miss Siciliera, if she's available, maybe.
Bulgaria, no?
No, Bulgaria, yes, I think, yes.
Yeah,
I see
okay,
Mrs.
with the
Siciliera.
Bulgaria. Yeah.
Okay.
Thank you. Can you hear me?
Yes, we can.
Yes.
Okay. Amalia, could you please allow me to share my presentation?
Okay. Yes.
Because it's quite longer than the other one.
Okay.
A
moment. Okay, now you should be able to share the file.
I'm not sure. Can you see it?
Yes.
Okay. Hello, everybody. Thank you for the opportunity once again to be part of the meeting. It was very interesting for me to see how different are the national legislations concerning legal entities. And you will see that the Bulgarian one is, I don't know, a mixture between other national legislations, because we are on our way to to involve them, the legal entities, more in the process of depriving the criminals, depriving the benefits from the criminals. So allow me to begin with an overview over the Bulgarian legislation concerning the Directive 2014 and with a focus on legal persons. Of course, the legislation is older than the directive was in place. So we have a lot of provisions which were amended to be compliant with the EU legislation. Our legislation provides for the following legal instruments for securing and confiscating the benefits of criminal activity. The first one is securing property subject to confiscation and deprivation in favor of the state, and the respective provisions are mainly two. The first one is in the criminal procedural code, and in another act which is called Administrative Violations and Sanctions Act. I will tell you more about this act further. The second one, of course, is confiscation or deprivation in favor of the state of property acquired through criminal activity. This is the Article 53 of the Criminal Code. We had the chance to explain about it when talking about confiscation from natural persons in our presentation over the first questionnaire. And the third one is penalty of confiscation. This penalty is, of course, imposed only on natural persons. I mention it because the confiscation can be imposed on shares which natural persons have in legal entities, and this is a way to affect indirectly legal entities. The fourth one is imposition of administrative sanction. It's a property sanction against legal entities and sole traders pursuant to Article 83A and the following of this Act, Administrative Violations and Sanction Act. The proceedings are of a criminal nature within the meaning of the European Convention of Human Rights, along with the pecuniary sanction, which is of a penalty nature. The court can confiscate the direct or indirect benefit received by the legal entity. It's a principle in Bulgarian criminal legislation, as I understood it is in other countries. A legal entity cannot be held criminally liable. Only a natural person can be the subject of criminal prosecution. And this defines a lot of the order that is implied to legal entities. It means that confiscation of property owned by a legal entity which had been used to commit a crime or acquired through a crime does not constitute, it cannot be a subject of direct confiscation within the meaning of the directive. Because, of course, the direct confiscation, as we understood, is something that the court may impose only with in regarding to the convicted person who had committed the crime. One part of the amendments in the Bulgarian legislation affect legal entities through the possibility of confiscation of criminal benefits together with the conviction of the crime. This is the Article 53 in the Criminal Code. This is a possibility which it is in our law because the Article 53 does not impose any personal specification. In practice, it is assumed that the provision regarding benefits can apply to both natural and legal persons. And sometimes in practice, the court does that, but I'm afraid not very often. The second direction of changes in the creation is the creation and improvement of an administrative penal procedure for sanctioning legal entities in connection with the crime provided for the Administrative Violations and Sanction Act. This sanctioning has two components. The first one is sanctioning a legal entity for a committed crime by a natural person with a financial penalty, and within the same procedure, the court must impose a confiscation of property representing funds and benefits from that criminal activity. To be clear, the Administrative Violation and Sanction Act was and is focused mainly on imposing a fine against legal entity when a person connected with this legal entity has committed a crime, and is not so much focused on confiscation of a benefit which was obtained by that legal entity. So the procedure is focused on imposing a financial penalty, and within this procedure, a confiscation of property may be imposed by the court if the benefit was not confiscated during the process of convicting the natural person which has committed the crime, The confiscation or deprivation in favor of the state of criminally acquired benefits from legal entities can be done in accordance with Article 53 of the Criminal Code, or by administrative penal order under the Administrative Violations and Sanction Act within the proceedings for the imposition of a financial penalty. Indirectly, this one is a direct affection of the legal entities. Indirectly, the property of a legal entity can be affected when a natural person owning a share of it is punished with the confiscation of that share for a crime committed. About the models of confiscation which affect legal entities, we used the explanation of the different models of confiscation which we provided for the first questionnaire. The direct confiscation, Article 53 of the Criminal Code, is when a confiscation is imposed on a share of a legal entity owned by a person convicted of a crime. This is the only way that in which the direct confiscation may affect indirectly a legal entity. Confiscation of a value, it's when the direct and indirect benefit acquired through the crime is missing. This is a model of confiscation which is applicable to legal entities only in the meaning of them being a third part. Extended confiscation, this is the penalty, of course, applicable to natural persons, when includes the share owned by the convicted person in a legal entity. Confiscation without conviction. This is a model of confiscation which is applicable when the subject of the confiscation is a share in a legal entity owned by a person, and as Article 53 of the Criminal Code is applicable regardless of the criminal responsibility, it may be in place when, for some different reasons, a conviction cannot be ruled by the court. And confiscation from a third party, this type of confiscation affects directly legal entity, so it's a part of the next slide. As I said, direct confiscation is not applicable to legal entities. Confiscation of the value is partially applicable in the alternative provided for in Article 6 of the directive, confiscation from a third party. The legal instruments are two, as I said, Article 53 and Article 83A, paragraph 6 of the Act of Administrative Violation and Sanction Act. Extended confiscation does not apply to legal entities directly. Confiscation without conviction, as I already said, is applicable. And confiscation from a third party, when it is applicable, when it relates to the proceeds of criminal activity, the benefit of the criminal activity. The objects of the confiscation and its meaning, of course, these are terms that we included in the previous answers of questionnaires regarding this project, and I will go through them very quickly. Direct or indirect benefits gained through the crime. We have an explanatory provision included in Article 53 and the Criminal Code. The equivalence of the benefits, this is a quite clear term, and when instrumentalities of the crime has been used by the legal entities, they are also an object of confiscation. In cases where their possession is forbidden, the court may impose a confiscation to a legal entity as well as to natural persons. The elements that should be realized or to be assessed for the application of confiscation against legal entities. As I said, there are two different ways to confiscate anything from legal entities when the benefits or the instrumentalities are connected with an offense committed by a natural person. The first one is within the criminal proceeding which the court considers about the natural person. Article 53 is applied together with the conviction of the offense. Therefore, all requirements needed to convict a person should be met. If that person has a share of in a legal entity, or a legal entity has some instrumentalities used for a crime, the court imposes a confiscation together with the conviction. In order to impose Article 53 of the Criminal Code, it is required that the means or the proceeds are related to the crime. This relationship, this connection should be revised and by the court, and some evidence should be in place to impose confiscation. Sometimes Article 53 or confiscation may be imposed separately or without a conviction. This is the case when due to the death of the guilty person or escape and other reasons, the conviction cannot be ruled, so the same requirements are in place. The other way to confiscate assets from legal entities, as I said, is the procedure under Administrative Violation and Sanctions Act in order to assess whether pecuniary sanction should be imposed and to confiscate the benefit. The court should clarify the issues specified in the law. I put them in here. Whether the legal entity received an unlawful benefit, the court should have evidence about the existence of a connection between the perpetrator of the criminal act and the legal entity, existence of connection between the criminal act and the benefit obtained by the legal entity, the type of the benefit and its amount, if the benefit is a tangible property. Before mentioning the elements for freezing order, I should talk some sentences about the amount of this financial penalty which the law provides for legal entities. The law says that the legal entity shall be punished by a financial penalty of up to 1 million Bulgarian leva, but not less than the equivalent of the benefit where the latter is of financial nature. So, when we talk about proportionality, you can see that the court is quite free to impose a fine which is close to the benefit acquired by the legal entity, but when it is not a material benefit or it is difficult to estimate it, the court is free to impose a fee up to 1 million. So the freezing, let me go back. The elements that should be assessed for application of freezing order against legal entities. About securing property, which is property of legal entities, is quite difficult because, as I said before, when talking about natural persons, for securing property of natural persons, there are two ways in our criminal procedural code. One of them is to collect the assets as a material evidence during the pretrial procedure, and the other one is Article 72 of the Criminal Procedural Code as precautionary measures. The problem is that the procedure under Article 72 of the Criminal Procedural Code is not applicable to legal entities, and the reason is that according to that article, it is applicable only to the person in charge. And as I said, legal entity cannot be criminally liable for committed offense. So the precautionary measures are applied only to natural person who has committed an offense, and it has been has been put in charge for that offense. The only way which the Criminal Procedural Code allows the pretrial authorities to secure assets which are property to legal entity is if we have information that some assets are in a property of legal entity, and we go there and collect these assets as material evidence, which are part of the pretrial proceeding. The other act which allows precautionary measures, the Administrative Violations and Sanction Act, allows that kind of measure. The problem here is that this measure can be applied only if proposal is filed to the court to impose financial measure against a legal entity. And as we can see further, this proposal is allowed by this act only after an indictment against the natural person connected with the legal entity is filed to the court. So you can see that during the whole pre-trial procedure, this kind of precautionary measure under this article cannot be applied, because only after an indictment or the start of the trial allows us to make such a proposal to the trial against the property of a legal entity. These are possibilities to apply the measure without a conviction, but this is only regarding Article 53 of the Criminal Code. It says that it is applied regardless of criminal liability, but I'm afraid that it is has only use in rare cases. Legal nature of the confiscation against legal persons. The measure under Article 53 is defined in our law as another or additional measure of property nature. The term is depriving in favor of the state, and it is a consequence of a committed crime and can be equated with that of confiscation within the meaning of the directive. The second one, the procedure under our Administrative Violation and Sanction Act, is a sanction of administrative criminal nature. We have that mixed nature, something between administrative law and criminal law, which is applicable against legal entities. But it is more close to the criminal because the criminal law and the criminal procedure, because the Administrative Violation and Sanction Act has an article which says that for all the matters which are not part of this Administrative Violation and Sanction Act, all the matters are should be regarded against with the rules by the Criminal Procedural Code. I'm going to mention it again. Furthermore, the procedure for application the deprivation in favor of the state under Article 53, the court imposes a measure as a part of the sentence, as I said before, and the confiscation is applied by the court ex officio. There is no need to be explicitly requested by the prosecutor, the court is obliged to apply it when the conditions are present, are met. The procedure, the other procedure, which is under the Administrative Violation and Sanction Act, as I said, it is initiated on the basis of a proposal of the prosecutor, who is competent to consider the case for the relevant crime. And the proposal must contain specific details determined by law. As I said, the moment that this kind of proposal may be filed in court is when the indictment for the respective crime is already in court. The first instance are district courts. Decision can be appealed to the appellate court. In relation to legal entities that are not registered on the territory of Bulgaria, the competent court is the Sofia City Court. And the decision of the Court of Appeal is final. There is one decision concerning Bulgarian confiscation model against legal persons of the Court of Justice of the EU. The judgment is of 2022. The question which was considered by the court is whether Article 48 of the Charter of Fundamental Rights of the European Union should be interpreted as precluding national legislation under which a court may impose on a legal person a criminal penalty for an offense for which a natural person who has the power to bind or represent that legal person is eligibly liable, where that liability has not yet been definitely established. In other words, the question is whether the legal person may be punished with a fine or financial penalty when the natural person is not convicted with a final conviction. This question is connected with the fact, as I said, that the Administrative Violations and Sanctions Act allows the prosecutor to file a proposal for that fine in the court after the indictment, and the law does not require a final conviction to impose such a sanction to a legal entity. And what is the ruling? The court says that this article must be interpreted as precluding national legislation under which a national court may impose on a legal person a criminal penalty for an offense for which a natural person who has the power to bind or represent the legal person is liable, where that legal person has not been put in a position to dispute the reality of that offense. In other words, this decision has been understood by Bulgarian courts as following. If the legal entity has been part or has been summoned to be part of the criminal proceeding within which the natural person liability has been disputed, a financial penalty may be imposed on that legal person. If the legal person has not been part of the criminal proceeding within which the natural person has been convicted, so the court must wait for the final decision and to give opportunity to the legal entity to present present evidence against confiscating the property or imposing financial penalty, and to present evidence that the legal entity has nothing in common with the person that committed the crime. Further on the questions which were part of the questionnaire, other measures to prevent or react against the involvement of corporations in crime. We have draft law, which is not a law yet, which proposes to the Parliament to have in law a pecuniary sanction or legal entity that was created or used for a terrorist crime, for money laundering, or for a crime committed in execution of a decision of an organized criminal group. In the criminal law, we are, because I was part of the working group, we are proposing a sanction in the amount of not less than 5% of the annual turnover of the legal entity in cases where it has received or could have received a benefit of a criminal nature, but the amount of the benefit is unknown or is of an immaterial nature. Again, this is a draft law, so it's not a fact in our legislation. The project provides, along with the property sanctions, that the court may also impose some of the following sanctions. I heard something like that in the presentation of my colleague in Spain. Temporary ban on participation in public procurement procedures, concessions, and obtaining EU funds, and other bans. You can see them, but we are waiting for the Parliament to decide on this draft. The problems, as I said on our answers of the questionnaire, they are not the problems in applying the regulation 8005. They are not so different than we mentioned before in the previous questionnaire. Sometimes when we are mostly an executing country regarding international cooperation and execution of confiscation and freezing orders of other countries, and identifying the competent court sometimes is a problem. Correct translation of the certificate, identifying the assets, and so on. Let me see what else I have here. The grounds of refusal, they were a part of the questionnaire, the previous questionnaire. As a conclusion, I must say that our law, our criminal law, has been focused so much time on the criminal liability of the natural persons, and not so much on depriving the criminals from the illegally obtained assets. And this is something that we are working on now, but the process is not finished, and it is connected with the fact that legal entities, unfortunately, are not so much in the focus of the pre-trial criminal proceedings and the investigations, because the law does not allow so much for freezing the assets when the assets are belongs to the legal entities, and until we reach indictment filed in court against a natural person, the legal entities that sold their assets, and there is nothing to confiscate or freeze at that time. So this is from my side. I can answer or explain further if you have any questions.
Thank you so much for this rich presentation. I have a question. So the administrative liability of a legal person is connected, demands the conviction of the natural person. It's not possible to consider the legal person liable also in an administrative way without the conviction of the natural person.
This is quite interesting because the law, as I said, requires an indictment against the natural person filed in court in order to the prosecutor to file a proposal to impose a fine to the legal entity. But the proposal is okay to the court, but if the court has not received a conviction, a final conviction against the natural person, the court does not impose financial sanction or a confiscation against the property of a legal person.
Yeah. So, okay. Yeah. No, because in Italy we have also Amalia, in Italy is it so? No.
Yes, sorry?
Is in Italy so? Because we have also the autonomous liability of a legal person when it is not possible to find or the natural person is not guilty. No, of some case, but no, I am to try to remember. Can we apply a measure, a sanction against a legal person? If I suppose that in Italy is the two proceedings are not connected, no? Are autonomous.
So there is the rule of the simultaneous processus in theory. So both the two proceedings should be contextual in the same time, and the rule of autonomy is really an exception rather than the rule, because as you said, it is very limited to those cases in case of the author is not identified or is incapable. So yes, actually it's a dependent liability, not an autonomous liability as a general
I was taking this case in front of the European Court of Justice. That is a Bulgarian case. In this rule, the acts for which this ground of refusal, the act for which the person has been sentenced does not constitute a criminal offense under our legislation, is always for a case, for a crime, for an offense, which is not included in the 32 offense, no? For which there is the mutual recognition.
I'm sorry, Anna Maria.
No, my question is, you have said that one ground for refusal is that the offense does not constitute a criminal offense under our legislation. But for the application of the regulation, in any case, there are the 32 offenses which are considered in the regulation in relation to which it is not necessary the double criminality, no?
This is rare cases when the foreign court issued a freezing or confiscation order regarding an offense which is outside the scope of those which does not require double criminality. So these are very rare cases, and they lay outside that scope.
Yeah. So some of these reasons, ground of refusal, in any case, are the same, no? Also for natural person. Yeah, in the praxis. After I would like, maybe we are a bit tired, but after I would like also to speak about another case, a Bulgarian case in front of the European Court of Justice, but for another aspect. Okay, we can make our lunch pause, even if it's a bit late. I say 3 o'clock, or a 3:15, or you prefer? Okay, 3 past. Okay, 3 past meridian at 3 o'clock, and have a nice lunch. Okay, see you later.
Thank you. See you.
See you later. Thanks.
Yeah.
See you later. Have a nice lunch. See you.
Bye.
A kind of case that they also have. Second is when we have a kind of transfer, and this is a complete and prompt transfer. So this means that every flow of the assets resulting from the offense is transferred from the first stop is in the legal, so the assets go in the legal person in the company, but after we have a full transfer and immediate timely transfer to the perpetrator, so to the organ, to the natural person. And then we see that in these cases, and this was my question basically to the Portuguese colleagues, there we see that again we have a direct confiscation against the organ, not against the company. And third case is only is also this kind of transfer when we see that it's kind of a doubt, so we are not sure here. We see that it was a transfer just partial and untimely, but also in this case we see that we have a direct confiscation against the organ. So these are three categories that the case law evolved, and that we see how it could influence the assets of the third of the company indirectly. In the next slide, we can see the confiscation against the company directly, and here we have to mention preliminary mention that, of course, as you know, in Germany we don't have the criminal liability of the legal persons. It's a big issue also in the politics. They tried to pass it last legislative period, but they failed. It was extreme discussion with all the interesting parties, the judges, the prosecutors, and now they are about to make a new proposal, a new draft law about end of the summer, as I know from the parliament. So we will see if something will change. If something will pass, then we will have some changes also in the confiscation rulings. So this was also in the previous law, so we have to track it. Here with the current situation in Germany, these are the legal bases where we can find the confiscation against the company. The first is, as I said before, this Article 73B StGB, so the third party confiscation. And after we see that also we have the 74A and C, and there we have the confiscation of the instruments. So we have also this kind of possibility against the legal parties. So confiscation of products of crime, means of crime, and objects, and also the value confiscation in 74C, and the value confiscation in 73C. This is something that, as some colleagues said before, it's the thing that is happening more in the practice. So value confiscation, either of the proceeds or of the instrumentalities against the legal person. And after we have also the Articles 29 of it, there is the administrative confiscation, and this could happen against also again on the value of the proceeds. So we see that there we have some legal bases that in the practice are used from the courts. And I think that the one that we see, and it's more in the practice, is this third-party confiscation. So next slide. And sorry, I forgot to say that also extended confiscation or non-conviction-based confiscation, and we will see it in the procedural aspects after it's possible against legal parties. Exactly. So now we have some interesting cases that I found. So we have to think when we have some limits. And the third, I bring the first point. So the third party confiscation of the section 73B, paragraph 1, number 1. So these representation cases that I said before. can be ordered, so these are the application requirements, directly against a legal person as a third-party beneficiary. First, when the increase in assets or cost savings, so we see that it's not the increase of assets, but also the cost savings, occurs exclusively for the third party. And there is where they make the interpretation, the judges, and they say that it should be the gain exclusively to the legal entity, even if the perpetrator had legal access to the assets. This was the question that I asked to the Portuguese colleague. So is the second point, the mere possibility of having access as a shareholder, manager, or authorized representative to the proceeds of crime, so from the status of the natural person, doesn't bring something, so that you cannot confiscate the assets directly from the natural person. So it's something that the Begge has said that it's not enough. This requirement is not enough. If the shareholder just has some access to the assets that obtained from the crime, is not enough in order to confiscate these assets from its private property. Another point, there were cases of merely occasional transfers to personal assets, and there also the Begge has said that this is not even it's not even a transitory possession, and there I'm citing what exactly was mentioned in the case of 2023. So it says, however, objects that are taken into possession for a short time as a means of committing the offense, or occasionally during the commission of an offense, the so-called transitory possession, are not yet considered to have been obtained within the meaning of the section 73(1) StGB, because there is no legally relevant inflow of assets in this respect. So here we see that this kind of cases of merely occasional transfers is also something that we have to put a limit, so an obstacle to confiscate the assets from the person. Next, please. Another interesting constellation is this of the enrichment of the legal entity. So we have the case enrichment of the legal entity, and after the subsequent increase in the value of the company shares held by the offender. And this was a really interesting case because Begge has said that this is also not sufficient, this indirect enrichment of the order of the company, because his or her shares gain in value just from the enrichment of the legal entity is not enough, is not sufficient in order to ground that the offender has obtained something from the crime, and therefore no direct confiscation against these shares of this person is possible. So the relevant argumentation was that first, it cannot automatically be assumed that the economic value of a company share in the private assets of the perpetrator increases with every kind of inflow to the company. And second, the confiscation must reflect the value of the assets that the offender has gained from the offense. And this was not met, this precondition here, because exactly just to keep it in mind, increase in value of the assets, increase in value of the shares of the person cannot, so these shares cannot be confiscated. It's not enough for the Begge. Next, yes, here we have the procedural aspects, and this was I mentioned before. It's really interesting to see that when the legal entity should participate in the confiscation proceedings, it will be the case that it participates as party affected by the confiscation. So this is the articles 442 StPO, and these are called the Einziehungsbeteiligte. So it gains the legal person another statute, not as accused, but as party affected by the confiscation and participating in this kind of proceedings, but also it can participate in the independent confiscation proceedings. And this is what we said before in these non-conviction based confiscation proceedings. So key observation here also in the literature, it was that even if corporate criminal laws, we said before in the traditional sense, does not yet exist in Germany, the company as party to the confiscation, so when it participates in this sense, de facto has the role of a party to the crime, because all the safeguards that are given to the accused basically is transferred also the same all the safeguards are transferred also to the legal person, so said in the literature. So we see that it is therefore true. I brought here like a point that the new Asset Recovery Act of 2017 was a kind of first step towards this corporate criminal law, strengthening the participation of the company, albeit not as a defendant, not as a Beschuldigte, but as a party to the confiscation proceedings, both in this white-collar criminal investigation and in the main proceedings. So we see which kind of role basically confiscation plays also in the big question that we have, criminal liability of the legal entities in general in Germany, and maybe it could be a kind of a criminal liability from the side door. It's mentioned. So here also to just a little point to make. Of course, this is just from the procedural aspect, but the legal nature of this confiscation against the third parties, it's not changing. So it remains the same idea that it was not dealt yet from the Constitutional Court separately, but we are based on all the commentaries are based on the idea that we don't have a penalty. Also, in this case, we still have this kind of civil law and enrichment. So it's the same as we said in our previous national reports, not a penalty. So we have here, we see here that the legal entity can participate in the investigation stage, but also in the main proceedings. So participation of the company as a third party is possible under Article 426 StPO. And in this context, of course, has, again, as I said, all the safeguards, possible hearing, statement of the party affected by the confiscation in the investigation proceedings, and all the provisions on questioning of the accused person must be taken into account also in this case of the legal entity participating in the confiscation investigation stage. The same could be said also by the participation in the main proceedings. These are the relevant articles that I mentioned here, so that it should be guaranteed again all the question rights, right to ask questions, to submit motions, and also right to submit motions for evidence. So next slide, please. The problem is exactly, again, in the right to silence. This was what was mentioned also in the literature, exactly also for the legal person. So confiscation against legal person and right to silence is a big issue, although the German legislator of 2017 recognizes that third parties participating in the confiscation proceedings have the rights to question, to make motions, as we said before, to request evidence, does not protect explicitly their right to silence. What means this if we look the law into detail? So it has a passage that it says, rather it will be necessary to take into account that the position of the confiscation party is more comparable to that of a defendant in civil proceedings than to that of an accused person. So here is the point that we always make also with Professor Maugeri. We have what kind of really standard of proof we have here, because here the German legislator in the text mentions that it's kind of more similar to the status of also the legal person of a defendant in the civil proceedings. And of course, this is also maybe explained because it does not want to bring ideas of criminal liability of the legal person and to make it elevated to an accused person. And exactly. So after yeah, the last point is not something that I have to mention. Is I made the point. So please next. Exactly. We have also two other points here. Article 430 StPO also stipulates that if the third party affected by the confiscation fails to appear in the main proceedings, when duly summoned, then the case may be tried in absentia. So trial in absentia also in this case, it's possible. And Article 428 STPO recognizes also that the person affected from the confiscation order has the right to be represented by a legal counsel at any stage of the proceeding. So here we see that what I said before, all these kind of safeguards that they are extended also in these confiscation cases. And next slide, please. And this is the last PowerPoint thing that I wanted just to mention that in Germany, basically, if we see the cases, we have we don't have again statistics. So I checked again in the statistics that we have, and the national one, and there it's not separately. There is not a table separately to say what is happening with the legal persons. So this is a proposal, I think, that we have to make clear that all the member states should have, at least, if not for the regulation, at least for the national proceedings, a clear table how many of these cases of the independent confiscation, extended confiscation, or the direct confiscation, and third-party confiscation against legal persons is happening, because we don't have it in Germany. And what we have and what is working is this kind of alternative to confiscation, is this fine, this administrative fine of Article 30 of REG. These are the regulatory act. And this is, as I said, an alternative administrative sanction against a legal person. And the application requirements is that if a person authorized to represent the company, or a person with a management function of the company, basically there is a list of persons that they are listed, which kind of individuals are meant in this sense. If they commit as criminal or administrative offenses, again on its behalf, on the behalf of the company, then the company faces a fine. The company itself faces a fine of maximum 10 million euros. And again, it said in case of negligence, so there is differentiation on the limit of the monies that are that could be fined. And just for the avoidance of any doubt, of course, this kind of application requirement that not every offense committed by the individual will result in the imposition of an association fine or of an administrative fine, but only if the offense or the regulatory offense involves a company-related act by the perpetrator. So this Article 30 of REG is what in the practice is really used. And it's a kind of solution for Germany, that we don't have the criminal liability of the legal entities. So thank you for your attention. This was what we had for this time.
Okay, thank you so much, Anna. I have a question. You told us that the standard with the proof is the civil standard. But in order to apply extended Einziehung, or also the self-standing Einziehung without conviction, no? So the extended confiscation, the non-conviction based confiscation. In the opinion of some authors, and also in some judgment, no, there is the idea that in any case the court has to be convinced. And in the past, is sure in some judgment, it was quite clear that the standard of the proof had to be like a criminal standard with the proof, no, in relation to the criminal origin of the proceeds. So it is different for the legal person. I haven't understood. When the confiscation for natural person can be applied to legal person as beneficiaries or third parties.
No, I basically didn't maybe mention it well. It's not changing. It's something that always existed also before. The legislative text in this reform, the explanatory memorandum of the law, it's mentioning, it says this thing, that it should be more near to the civil defendant of the civil proceedings. But after the commentaries, and as we see from the Article 437 from the STPO, there we see that we need, how it's mentioned again, we said it also in previous reports, this standard of proof, we are basically looking at there, and it's this in between. So we don't, it's something that it's different how the legislator ruled it and how in the practice now the judges are applying this article. So it's something in between the major idea.
Okay, this is an explanatory report of the reform of 2017.
Exactly, in the explanatory memorandum. I can
But
send
this
you
is also for
the
natural
page.
person. So in the end,
Yeah, it's
even if
basically
the
it's what
proceeding is in front of a criminal judge in the end, no? Is a kind of criminal proceeding. Okay,
yes.
okay. And are there some judgment about this standard?
Exactly, now I cannot, I didn't search it for the standard, but I can put it in the report. I can find something concrete.
Yeah. Okay. What is for me always, I have some doubt about the opportunity to introduce, we don't have in Italy, but you have in Germany, this confiscation of the value of the instrumentalities. Because in my opinion, this is a real punishment. Because the ratio, no, the aim of the confiscation of the instruments of the crime have to be interdictive, preventive in the real meaning, no? The states, the authority takes the instruments in order to avoid the use of this instrument in other crimes in the future. But if you don't take the instruments, but you take the value of the instruments, is only a fine in the end. No? So with all the problems, also in the directive, also in the new proposal of a directive, no, there is the principle of proportionality, but is more in the stricto sensu in relation with this confiscation of instrumentalities and the value of instrumentalities. So is there some debate about this aspect in Germany?
Yes, because we have to separate always in our mind this difference between the 73 and the 74. So when we come to the 74, there are in the literature there are authors that they say exactly what you mentioned, and this also this brutal principle that we are really going beyond. But the legislator, I mean, the text is like that for the moment. We will see they are planning a reform to the law now, and we will see maybe till the end of this legislative period, so 2027, and what I say, 25, sorry, they may change it. So we will see what kind of changes we will have. It's a good point to make this, but in the literature, yes. If now it will pass in the law, a change, I don't know it yet.
Yeah, another important aspect today we haven't spoken about this aspect, but this is important for every system of law. Is the issue of the net or brutto principle, no? This issue. So if it is possible to confiscate the proceeds considering the expenses or not considering the expenses, is, in my opinion, the issue is a real and important issue, in particular when we apply confiscation against legal persons. Because in that case, in my opinion, it is very significant. For example, if a company has got a grant, a tender in order to build a street, a building, a school, and so on, with through corruption or fraud. Is it if in any case the company has built, has realized the school, the building, the street, the road, and so on. Has realized a lot of expenses in order to realize this the object of the tender of the grant. In any case, in my opinion, it would be better to consider these expenses in order to avoid that the confiscation is not anymore the confiscation of proceeds, but is a kind of punishment. It is different, the issue, if we speak about the illegal expenses. So in my opinion, in the end, there is not so a big difference between the position of authors who demands the net principle or the brutto, gross principle, because if we agree that the illegal expenses we cannot consider, but we have to consider the legal expenses in favor of the community, of the states, of the authority. I think that if we want to respect the principle of legality, confiscation of the proceeds and non punishment, in any case, and the principle of proportionality, we have to respect. I think that in Italy it is sure so. This issue raised in relation to legal person, or not when the confiscation was applied to legal person. And until now, this is an important issue. In Italy, there is this position that it is important to subtract the utility for the victim of the crime, but it's not clear what is the utility in the position of the Supreme Court. There is a big debate. Many authors criticized, also me, criticized this position of the Supreme Court. It is easier to consider the legal expenses in favor of the community. But I know that also in Germany, this debate is always, and also the reform has changed something about this aspect. Can you?
I just sent it to you. It's this article that they made it more.
Yeah. There is a new rule. It's clear, a more clear rule.
They tried to make a kind of calculation exactly with steps. So there are the authors that they say that now we don't have a gross principle, but a minimized gross, something between gross and net, because they're making the calculation. I put yours in the English translation if you're.
Yes, I know. Maybe you can also read this rule for the others, because I know this rule, but this is a important moderate
exactly, gross principle.
Brutto principle. It is interesting because it is clear, so in article I wrote that it would be better to write this rule also in Italian system of law in order to be clear, no? Can you read for the others?
Yeah, of course, I can also read it.
Translate
I send it from the official translation. So it's the section 73D, calculation of value of the obtained object, so estimate. And first it says that when calculating the value of an object obtained, any expenditure on the part of the offender, participant, or other person is to be deducted. So this is the first step. An amount spent or used in the commission or perpetration of the unlawful act is not deducted. However, unless it was used to comply with an obligation against the injured party. So we see the exception of the exception after. This is the point.
Yeah. Okay. And another interesting issue about the concept of proceeds when we apply confiscation against legal person is also, but also for natural person, is also if we can confiscate the indirect, the utilities, the Nutzungen, no? The indirect profits, the profits over the proceeds over the proceeds, no? And also in Italy and also in the other countries, no? In the other system of law, there is always this issue, which is the limit, no? So I know that in Germany there are some approach, some orientation over the case, over the jurisprudence of the case law in order to avoid the confiscation when is the utility, the indirect proceeds are also the fruits of the legal work, of legal capacity, no, of the, for example, of the businessman, no. This is interesting rule, no. Okay, because in Italy. This is not so clear in the debate, no? In the opinion of, sometimes in the opinion of the jurisprudence, the idea is that is not possible because it's indirect. Sometimes it's possible because in any case, what is enough is that it's possible to give some evidence, circumstantial evidence of the connection with the original proceeds, but there is not this consideration of the legal activity, no, or the legal of the capacity, no, of the businessman to realize a good investment and to limit the confiscation. Because the idea is that if the original capital is illegal, also, no, the utility, the indirect proceeds are illegal. This is interesting. Can you say something about this aspect in the German consideration debate?
The only thing that now I don't have exactly the article in my mind, but the only thing that I know is that they are argumenting with these Nutzungen that the people that they are wanting to say that there is no proportionality principle and so on. It's an argument that they take from this article. But unfortunately, I cannot say more.
No, the article, okay, say only that it's possible to confiscate the Nutzungen, not only the Surrogaten, but also Nutzungen. Nutzungen means indirect, the proceeds of the proceeds in short way, but there is a debate in the case law about this.
But of course, these are just to make it clear. It's just also the what we mentioned in the first report. So it's not something that it's just for the legal person. So we're going in the general 73. And let's check.
Are there other issue for Anna? No. So now, Amalia, we have some news about to France and.
No, France told us that they cannot take part in the event. About the representative from Poland, he appeared a few minutes ago, but then he disappeared again. So I think that.
Can we maybe send an email, a message?
Okay, I wrote to them, but I can write again. But.
Okay, maybe Jurate has Jurate solved the problem, or is
I think that she isn't here anymore. She isn't here.
She isn't here. Okay, So in any case, France has sent the report, so we can also share the report with the others partner.
Yes.
In order, but they are ending, they are trying to improve the record. So maybe we can wait for the last version of the French report in order to share with the other partner. And maybe we can do the same with the report of Lithuania. And we have also the slide, no?
Yes.
Yes, we can send also these slides in order to to know better the system of law of this country, and the same for Poland. I don't remember if Poland has Poland sent the report.
Yes, they sent it today,
Yes.
I think. Today
So
morning.
we can also try to share with the other colleagues this. I would like to remember, but that there is a recent case in front of the European Court of Justice, where the court ruled out that the Bulgarian custom authorities competent for issuing a form of confiscation, but not in connection with a crime, did not fall within the notion of a court as required by Article 2, paragraph 4 of Directive 42 of 2014. So Bulgarian it is interesting because in this case the custom authorities are competent to apply a form of confiscation, but not in connection with a crime. So the European Court of Justice specified that the confiscation ex article 4, in this case, of the Directive 42 demands presuppose a crime. It is important, a crime. This is very interesting. It is specified. It is sufficient to note that first, in this case, in the main proceeding, the administrative penalty notice was issued following an administrative procedure, which did not relate to one or more criminal offenses, and even less to a criminal offenses punishable by a custodial sentence of more than 1 year, as required by Article 2 of Framework Decision 212. The court used, in this case, the case is about also the Framework Decision 212, but the court specified that in any case, the court has to consider the Directive 42. I would like to stress that notwithstanding, in the opinion of the European Court of Justice, authority competent in criminal matter, as we analyzed in the Balaz case in 213, is an autonomous concept of the European law. In the Balaz case, the court said that it was the Verwaltungssenat, it was an administrative authority in that case, which applied a fine, a sanction, a fine, so a fine, administrative fine. In that case, the court, in Baraz's case, affirmed that the administrative authority was authority competent in criminal matter because it is not important the qualification of the sanction by member states, and because the proceeding was a criminal proceeding, a criminal procedure with the safeguards of the criminal matter, the respect of the principle of legality, of guilty, of proportionality. In this case, the approach of the court is different, but what is, in my opinion, the very important element is that the court affirmed that in any case, in order to apply the directive, the matter has to be a crime. The confiscation has to be connected, has to be the consequence of the commission of a crime. So this is interesting. The issue for the future, I find also another issue in front, another case, but it's also in the first stage. The European Court of Justice has to decide if another confiscation, administrative confiscation, can to be covered by the directive. So this is one in fundamental issue that we have to carry on to study, to check for our research. On the basis of it is judgment. The judgment is, I can send you, maybe we can also share in or include in our database the most important decision of the national system of law and of the European Court of Justice or European Court for Human Rights. In any case, this case was was against very difficult to yeah, it is very difficult to Otto del Mitnichesco is very complicated. The number is 752/21 and is against Bulgarian. So, are there other issue?
Sorry.
So, please.
Can you repeat the number?
Yes.
Please.
752.
Oh, thank you.
/21. European Court of Human Rights. Okay. Okay, so and yeah. Okay. Okay, Amalia, have we something to say for the next step? It's important to gather the
most important thing
report.
is the report. Hopefully by the end of this week, if possible. Otherwise, because by the end of March, so by the end of the next week, we have to present to the EU both the national reports and the best practice and guidelines and so on. So we need the national reports to gather all this data. So, and then in April, the next work package will start about asset recovery office and the management of assets, but you will receive the necessary information in due time.
Okay. The Italian Ministry of Justice told me also that they are gathering the statistical data about the application of the regulation in relation to legal person, because now we have a new system of gathering with more specific indication, but in the first years, the data are not so precise, no? So it is they have to check if in which case a legal person or in any case a business was involved in the application of the regulation. So if nobody would like to intervene to say something, I suppose that we can conclude and our workshop. And I pray you, every partner, to send us also this recent case law which has been quoted today of the national courts, of the national case law, European Court of Justice case law, and European Court of Human Rights, because it is we can include in our database. It is an important, very important instruments to better know this complicated system of confiscation and mutual recognition. So thank you so much, and happy Easter for everybody. And I hope also happy holidays if it is possible. Okay.